Yes.
Your Lordship, I need to mention one contempt matter.
This bench?
My Lord is there.
With whom?
My Lord with I don't know.
Then contempt, if the other brother judge is available, then it has to be heard before that bench. First ascertain. Yes.
But I am mentioning one order 41 matter.
Yeah.
My lord, may be permitted to mention one injunction application, learned court below.
Application gave.
My lord, order 41 to
Gave.
Application.
And may permitted to mention
Give
one.
all order 41 and an application give. All order 41 applications. Any type of application. Give.
Lordship, this is also an application, Your Lordship.
No mention. Give.
Lordship.
Yes.
May I permitted to mention, one matter has been disposed of by your lordship. Now, my lord, dismissing the injunction application, where my lord, some tampering has been done. Your lordship directed for inquiry and other things, my lord. Now, what happened, my lord? Lower court record has been called for. Now, your lordship was by order dated 10th October 2023. Your lordship directed that record be kept with a sealed envelope before this court. Now, my lord, your lordship has been granted liberty to us to file appropriate application regarding rejection of the print. But as the original record is here, but I went to the London Register Administration, my lord. He says that there is a direction passed by your lordship, record be kept with the record. Now, my lord, kindly take it as to be mentioned, my lord, unless your lordship directs.
Give to be mentioned.
My lord, one matter for hearing, my lord, is a partition suit dismiss.
Hearing give.
May I have
Ready, otherwise ready?
Ready,
Paper
my
book
lord.
filed?
LCR has come, paper book has ready. Much of.
May I have your lordship's kind leave to mention item number 322 of the monthly list matter. In this matter, I am a defendant in a suit. In the order 39 rule 1 and 2 has been allowed. Order 7 rule 11 has been rejected. From the same order, my lord, this appeal has been filed and a revision has been filed in regard to the order 7 rule 11. On the last time when it was heard, it was my lord's desire that it can be heard together before this honorable bench. But if there's nothing in the order, my lord, so it's the revision is still pending before.
You know how to do it.
My Lord, may I have
We can't direct that it should be given to us.
My lord,
It is up to you what is required.
my lord, unless my lord.
There is no, sir, never these orders are passed, but still
My Lord, may I have
there are procedures.
may I have your
You have to understand the procedure.
may I have your Lordship to mention one Rajima matter?
My lord, may I give hand over the slip with the civil revision number to you, my lord?
We can't. We will say let it go out of list. We can't hear out the civil revisional application.
My Lord, it's my first appeal arising out of matrimonial decree, my Lord. My urgency is, my Lord. The appellant has filed the appeal since 2006. It is pending, my Lord. It was mentioned before Honorable Justice Soman Sen and Honorable Justice Uday Kumar, where it was taken up, directed to be listed after 8 weeks, my Lord. Thereafter determination. Urgent, my Lord.
Yes, 8 weeks.
My Lord, it has passed, my Lord. It was passed in.
There were 8 weeks. Then there was no urgency.
My Lord, the urgency was there, my Lord. Because
But why the other bench said 8 weeks?
my Lord, the paper book was not ready. Directions have been made bare. They are not complied. The appellant is not taking any step, my Lord.
Paper book is filed.
My Lord, that is my Lord,
Then
the order.
Lawajima.
No, my Lord, the paper book has been filed, my Lord, but
No,
they are
I'm
not
asking
taking
you,
any
madam, whether
steps.
the paper book has been filed.
Have-
Oh, my lord. So what we will gather from you?
My Lord, it is running in the list, my Lord. I want.
Be running, then we'll take up. Don't worry.
My Lord, kindly takes it in urgent.
Sir, madam, every litigant is equal before us.
My Lord, over here.
There are many matrimonial cases. Every matrimonial cases has to be given some priority. If since you have a persuasive appearance, that does not mean that we will jump the forum and the others are deprived because you are appearing. That we can't do.
My Lord,
Sorry,
kindly then upgrades it, my Lord.
No, madam. Sorry.
My Lord, the urgency over here is that I will
We will
not
take
get
up
the
all the
pension.
matrimonial matters in seriatim. We will take up. No. And these are all listed according to the year.
I've
Lord.
served the other side, my lord.
No. Next.
My lord, the paper book, regarding the paper book, my lord kindly puts in the Lavazima pen, because as far as the last report, they have not intimated us that the paper book, but there was direction that the paper book will be filed, my lord, by the last.
Give a Lavajima.
May I permit to mention for non-prosecution? Non-prosecution.
By all
May I be
means.
permitted to mention for inclusion of a matter was supposed to come on 12th February. But the matter didn't come up below because this merchants to Miller, the
We don't want to hear. Conserve your energy, exhaust on the day when the matter is listed.
lordship.
Yes,
Lordship.
call the list.
Yeah, my lordship. I'm praying for mentioning my lordship. It was for a withdrawal, my lordship.
Non-prosecution.
Cran one has been filed wrongly. It has some typographical and factual error. We have to withdraw it.
May I be permitted to be mentioned, my lord, this is application matter for injunction matter.
You need not have to mention matter. We have said that all applications you give.
My lord, one matrimonial hearing already been heard, my lord, both sides, my lord. You lordship fix the matter, my lord. Directed, personal appear both the parties directed to file a application for mutual divorce. My lord, matter, my lord, already been fixed, my lord, coming in the item number 107.
Let us see, sir. I was not there. I was in the circuit bench. Let me have some breathe.
No, my lord,
Today, let me have some breathe.
earlier occasion I mentioned, your lordship,
Sir,
lord, given liberty to mention.
Understand, sir. I understand. So today is a day after 15 days I am coming.
Any
So
day,
let
my lord.
us see this week. This
Yes.
week also is a dicey one for me.
Yes, my lord.
Okay.
Next one.
May I have your lordships kindly to mention a matter upon notice. It's a Group 7 appeal against the railways. My lord,
We don't
read
know.
petition was allowed,
Give,
but the only difficult I'll tell you, lordship.
give nothing telling. Give.
My lord, there's
Give the slip.
there is an urgency, my lord.
Then we are releasing the matter because I will not be available for entire week again.
So, my lord,
So-
kindly list it thereafter.
So mention thereafter.
So if your lordship indicates, my lord,
No, we'll give it. Hey, kalke to
Wait.
mention the karo.
any day convenient.
I will release the matter.
This matter is the.
No, my lord, kindly don't do that. Kindly don't do that, my lord. Let it
After fortnight, I'm not going away with the hearing. After fortnight.
in this matter. Oh, great. My learned friend is there. Well, 19 crores have been directed by the trial court to be paid based on admission by the railways. Well, I'll go into insolvency. Well, this is based on registration fee and license fee based on the my lord, Government of India circulars. I am entitled to that money.
Who are you? Government?
No, they are the government. I had a railway
Let
siding.
us see. Let us see. Wait. Yes, call the list.
Lord, certain developments have taken place, Lord, in the matter. Lord, we have been dispossessed by Lord execution. Lord, I have taken out an application. Lord, praying for an injunction in the meantime, and usual Lord directions for filing of a
Lord,
paper books may be
possession has
passed.
been taken on 20th of February, and my lord, my learned friend's client himself vacated the premises.
No.
It was lying vacant. My bailiff went there, took possession. There was no
Lord,
article.
Your belief.
There was no risk.
Yeah, his
Your
belief.
belief.
Possession
his
has
belief.
been taken on
You
20th
say
of
my
February.
belief. That's why I say your belief.
His
Court
belief.
bailiff, not my bailiff. I'm sorry.
Lord, we completely, Lord, we were Lord, unaware of the execution proceeding. We went
Well,
out of station in the meantime.
It was within 2 years. Then you are not
Yes, yes,
entitled
Lord,
to today.
I do not make
So,
any submission
what
on that.
more?
The only thing is,
All
Lord,
his application
Don't
have been
part with
yes,
first
First
appeal.
yes.
It's a matter of right.
I'm grateful.
So don't part with the position. Position is with you.
Yes, my lord. Possession.
Keep the position with you.
Yes, my lord.
Don't part with the position to a third party.
Yes, my lord.
Where is the application?
Lord, can 2, Lord, is the application, Lord.
Can 1 is
Can 1 is, Lord, the
stay.
application, Lord, that has.
They has become infructuous.
Let us dictate.
Yes, my lord.
Can 1 lekho. This is an application at the behest of the appellant seeking the stay of the further proceedings in the execution case pending the instant appeal. The counsel for the appellant submits that during the pendency of the instant appeal, the position has been taken by the respondent in an execution proceeding through bailiff. In such view of the matter, the instant application has become infructuous and is accordingly dismissed. Next, can 2. This is an application taken out by the appellant alleging that taking advantage of the position having obtained through bailiff appointed in an execution proceeding, the respondents are contemplating to create a third party interest. And in the event he is successful in doing so, it will create a multiplicity of the proceedings. Therefore, sir, the counsel for the respondent submits that the position is obtained through due process of law, and there is no intention of his clients to create any third party interest in respect of the suit premises. So, in such view of the matter, the respondents are restrained from alienating, transferring, and or parting with possession of the suit premises in favor of a third party until the disposal of the instant appeal. The application is accordingly disposed of. Let the lower court record everything has come.
Lord, LCR has not yet come. There was no direction of that.
Yes. Let the lower court record be called for through special messenger at the cost of the appellant. Most of such costs shall be put in within a week from date.
Within this week.
Then examination of the lower court record. Then notice under Rule 12, Chapter 9. You are representing entire set of respondents, plaintiff respondents.
Yes.
Lord,
You are
that can
representing
be
the whole set of plaintiff respondents. Is there any other respondent?
Lord, the pro forma respondent is there. Lord,
you are
take the
waiving
risk. I take the risk, Lord.
Yes. Since the plaintiff respondent has entered appearance, you have filed the Vakalatama.
My lord?
You have filed the Vakalatama.
Yes, my lord. Yes.
Can you give me the number?
Not now, my lord.
Filing
ফাইলে হবে কি ফাইলে
ফাইলেই থাকার কথা
হ্যাঁ ফাইলে হবে
File में है file.
this matter, my lord, a caveat was also filed.
What?
We had served them based on a caveat.
Caveat.
Yes.
Let us see. Since the plaintiff respondent has entered appearance by lodging a caveat, appearing number 654/2023 on 20th February 2023, let the Vakalatama annexed to the said caveat be tagged with the instant appeal. The appeal shall be treated ready as regards service so far as the plaintiff's respondents are concerned. The counsel for the respondent waives the service of notice of appeal. So far as the pro forma respondent is concerned, since he was arraigned as a defendant in the suit and did not join with the appellants in the instant appeal, on the prayer of the appellant, the service of notice of appeal is dispensed upon the said pro forma respondent is dispensed with at his risk. Liberty to mention paper book within 4 weeks from the date of service of notice of allowance.
I'm grateful.
My lord, rupees 20 lakhs is due as rent. They have not paid the rent.
Execute.
The execution complete. They are in possession.
Recorded satisfaction.
They are in possession of the property. Not Perhaps not on 1st of March, my lord, the next date is fixed.
So for money, they will.
They will not proceed.
So before your lordship, before I say something, sir, your lordship, before I say something,
Lord, item number 2 is appearing at our instance. The interim order is still tomorrow. My lord, may I indicate what happened? This is the matter where your lordship in the first round of appeal was pleased to, this honorable court was pleased to direct the trial court to hear out the application and was pleased to extend the interim order for a particular period.
But that was not extended.
That was
Then
not
you
extended and your
filed
lordship.
a revisional application.
No, that's a separate matter. Well, that's somewhat similar facts. That is why, my lord, your lordship is saying. So, my lord, we had preferred an appeal, and your lordships on hearing.
I understand. Then where is the other side?
They are not coming. We have served. We know 3 addresses of theirs. We had served in the first address. Both of them received. In the second,
In the trial court, have they appeared?
no. So your lordship will kindly remand it back with confirming the interim order till the disposal of the application,
Is it
which
a
shall once again serve. We have served, they're not appearing.
It's a correct English. Remanded back. Remand
Remand-
itself connotes back.
Your lordship will remand the matter to the trial court. I'm sorry. Remand is sent back. But may I file the affidavits of service? This would show that they had received this. Despite that, they are not appearing. They have received actual receipt.
नहीं किया वो expired का. They could not dispose of the application.
And the finding is that no direction to extend the interim order was given. On that premise, this was not done.
Injunction application not moved before this court. Why you did not move the injunction application?
But we had moved. But we had taken steps to serve. But there were several directions. We have put in the requisites, everything, and they have received it. Not each and every, they receive the mentioning notices. They receive every time before the trial court also all applications. They choose not to appear. And this is the plight, my lord, which we have to suffer. But all note, even mentioning notices, they receive everything. But we have always tried to serve and move. We don't want to steal a march on this.
Where is the earlier order?
Your lordship's order, my lord, the first order, kindly takes a look at my lord's order. Your lordship's my lord, order of 11th of October in this appeal. But we have even published in newspaper. Despite actual service, we have still then published in newspaper since they are not appearing. But we have done whatever we could.
Where is that publication?
Yes. Newspaper. Page 78.
My brother got it.
Page 78.
My brother got it.
One in Bengali, one in English.
The English, which one?
Yes, 78 and Bengali 78A.
Oh, no. Which one? Which one?
Both. Will kindly see. Will kindly see this portion, Milord.
Fourth column.
No, the third column.
Fourth.
But English is third column, Bengali is fourth column. And if your lordship kindly see.
Where is our order?
Yes, that is there in the order file of your lordships, 11th of October 2023. The first order in this appeal.
First order.
In the parent. Page 54, my lord, if your lordships kindly take. Passed by a coordinate bench, my lord. And then, my lord, the second is.
Oh, it is passed by the coordinate bench.
Yes. The ad interim was page 52, where we came up from the refusal to pass interim order, and after service at page 54. Kindly seize, my lord, page 55, paragraph 7. The learned trial judge may pass incidental directions with regard to the service being given. And so, my lord, incidental directions also, that goes without saying, my lord, in my humble submission, my lord. And if your lordships are pleased to take a look at your lordship's first order in this appeal, that is dated 11th of October. Then,
let the affidavit of service filed today be kept on record. There is no appearance on behalf of the respondents when the matter is taken. No, today it has come up for extension. So it's better to place the matter for order tomorrow. Otherwise, they will.
But they are not
say
appearing, my lord.
extension, whatever.
Possibly the 10th or
But
12th
sometimes-
occasion.
Sometimes somebody must be there and they will take advantage.
Let them come and at least apply. Let them come. But at least pass some harsh order.
You wanted us to dispose of the matter. We
Yes.
are really inclined to dispose of the
Very
matter.
well. I leave it to you,
We
lordship.
do
I
not want
understand.
to keep this matter open. But today it is appearing as
For extension, I understand.
Till tomorrow the matter is there.
Interim order is
is there. So tomorrow as 4 orders will dictate the order.
Very well.
Okay. There is no appeal. Let the affidavit of service filed today be kept on record. There is no appearance on behalf of the respondents. So stop. Let this matter be listed tomorrow under the heading 4 orders for final disposal. এটা যদি আমাদের সই হোক বা না হোক এটা কিন্তু কালকে 4 orders এ থাকবে।
I'm grateful.
Why you will not come? For orders. Where is Mr. Paulumi Chakraborty, Mr. Dutyman? Mr. Rudranil Das? Does not appear that the dutyman is the dutiful person. Where is he? ঠিক আছে আজকে প্রথম দিন পাস ওভার করো I am not the race item number 6. Where is the appellant? We have made a passover. Call 7.
Below subject the leave of the cook.
Why you are not taking steps? There are so many defects. The Lavajima court has passed as many as 4 orders to correct, to remove the defects. You are not really taking any steps.
There is some fault of my juniors in the sense he was sick sometimes and he was
But sir, on 10th of October, she must be sick. Then on 12th of October, I do not know. Then again on 20th of December, after a gap of 2 months, again the same thing. Then on 21st of December, the same thing. Today, when we are taking up in the fag end of the February, the same thing. Same thing. How long she is there unwell? From October, still continuing as unwell.
forgive me for the cause of the inconvenience. In fact, in this appeal arising from the match,
So everything is recorded, and I'm thankful that at least the Lavajima court has not dismissed, considering that it is a matrimonial appeal. Otherwise, could have dismissed. Why you will not do it? Why you will not remove?
once today I will comply.
At once what? Where is a certified copy of the judgment and decree?
Now, subject to the leave of the court, Lordship kindly see, this match suit was dismissed for default. Although the match suit was filed on the ground of cruelty and desertion. If your Lordship kindly see,
Who are you?
I being the husband.
Yes, your suit was dismissed for default.
Lordship kindly see.
Where? Now, give us. Forget about it. Tell us what is the wrong in the order. Tell us.
Now, subject to the leave of the court. In fact, marriage took place in the year 2000. Marriage took place in the year 2000.
I am asking, you are assailing an order of the trial court. Correct? Tell me what is the wrong in the order of the trial. Tell. First.
Lordship kindly
Is there any wrong that has been committed? Tell us from this order.
Subject to the match suit was dismissed for default.
Correct.
Default in that sense, court observation is that submitting the statement of account.
No. The court's observation is that you are absent, could not file any scrap of paper regarding the illness of the petitioner.
Kindly see. In the order dated 10th August 2023, kindly see, on perusal of the case record, it appears that the petitioner was directed to file the statement of accounts regarding the payment towards the alimony pendent till date, but he did not comply the order and went on filing the adjournment.
Sir, whatever be the grounds, you asked for an adjournment has been refused. Tell me what is the wrong in the order?
Miller, court direction to file the statement of accounts.
Not concerned, sir. Your ground for adjournment was not accepted to be a plausible.
And ultimately, court make the observation dismissed for default. Matter was not dismissed on merit because match suit was filed on the ground of the cruelty and desertion.
Sorry? You are assailing, you are filing a first appeal. Tell us what is the ground of first appeal. The court has said that you have asked for an adjournment. I did not find that the grounds which you have assigned for adjournment is proper, and then rejected the adjournment application and dismissed your suit. Now, what is the charm in a default? Let us see. When you say default, then tell us that in a first appeal, how far the first appellate court can enter into an order which dismisses the proceeding for default. Tell us.
Miller, subject to the leave of the court.
He could have straight away.
Miller, subject to the leave of the court. In fact, the court below has dismissed just on flimsy ground. Your Lordship kindly see in my ground also. Number 2, for that the learned judge of the court below.
Just wait. Or to perform so fit to appear order 9 for default. Order oh, so it is called now. This was the suit. Order 8, on an order 9 rule 8. It's the provision where it is dismissed then 70 dismissal plan. So they corrects me actually order 9 lines. It will be
You're subject to the name of the court. But before taking up the merit of the case, I'm telling you the nutshell of the case. In fact, this marriage was take place in the year 2000.
Sir, with deepest of respect and a humility at our command.
Yeah.
You have filed an appeal. That does not mean that the appellate court will rehear everything when the appellate court found that not a single witness has been examined by you. Nothing you have done in respect of a suit, and the suit was dismissed for default. If such is the nature of the appeal, can the court go into the merit of the matter and then say that, yes, since you have pleaded, not proved, everything will be accepted by the appellate court to have been proved by you on the basis of a pleading. Question is here, court has not dismissed on merit. You can say that this particular finding on merit is wrong. We can understand these are the materials from record, these are the documents in record, but it is not so. Now question is, if it is dismissed for default, you have come up with the appeal. Now tell us that whether this order was justified, court was justified in dismissing it for default or not justified in dismissing for default. That's the only question.
That's the only point. Only point.
Merit will not go.
Very good. Now my respectful submission, your lordship kindly see, the appeal was dismissed for default. And what are my grounds I have taken for lordship kindly come into my grounds. For that the learned judge of the court below failed to enter into the merit of the case. Doesn't go. Because
How can he enter?
I beg to apologize, Lord.
How can he enter into the merit of the case?
Lordship, I am coming one point.
Yes.
The matter was under the heading, once it was under the heading of the examination, it is at the evidence stage. But the court below, bypassing that particular portion, come into that, how much amount of maintenance you have given stands on the point. And at one point of time, my client a senior citizen, retired person, he was not able to attend before the court, make a prayer before the court for the adjournment. Lordship, kindly see, I have taken one ground in point 5. For that, the learned judge of the court below failed to appreciate the sickness of the senior citizen. I, being a senior citizen, court overlooked this provision. Court come into the conclusion, finding of the court is that
Yes.
on perusal, if your lordship kindly see in the order sheet, it has been recorded. On perusal of the case record, it appears that the petitioner was directed to file the statement of accounts regarding the payment towards the alimony penalty line till date, but he did not comply the order, went on filing the adjournment petition on the flimsy ground. Well, I being the senior citizen is suffering, a sickness is that, and that petition I have made before the court, but court overlooked. My ground was that as I am unable to attend before the court to give the adjournment. Court doesn't go into that. Court doesn't go into the other ground also. Only state how much you have paid. How much? Very well. That is another point. I'm not denying to that extent. But my ground, a senior citizen is not able to attend the court, and I make a prayer before the court. If I come into the merit of the case in that event, if your lordship kindly see, the marriage took place in the year 2000. Since the death, within a 1 month she left. She doesn't like to stay with my family because my older father, my mother is there, she doesn't like. Upon leaving the house, she then started to file one after one other case, filing a complaint case under section 498, and that has been dismissed by the court below. Her mother also filed a mat suit. Her mother also filed a money suit against me. That has been dismissed. One after another case. DB Act, this Act, that everything is been covered. Now, at this point, if your lordship kindly see, this court is having a wide power.
How far? How wide?
Court is having wide power.
How wide? We are more concerned with that.
So far,
The appellate court has a wide power. How far?
So far, the deficit.
How big wide powers are there?
Yes. So far, the deficit court fee is concerned.
Whether the appellate court can ignore all the provisions of the law and then pass an order, tell us.
Section 149 of the city code. Court is
149.
Court is having a wide power.
Wide power. Let us read 149, sir. Let us read 149, sir. I do not know. Let us read 149.
Lordship has so wide knowledge.
No, tell us how wide it is.
Lordship has a
It
wide
is in relation to a
But it-
deficiency of the court fees.
There is
How
a-
wide? I am asking the
Exactly.
merit. I have invited you to tell me on merit.
I beg to apologize. One prayer before your lordship. So the deficit of 20 rupees is concerned. I have no any bad intention not to pay the 20 rupees, and I will counter. This was there are some
Mr.
bona fide
Counsel,
cases,
Mr.
I
Counsel,
understand.
that we noticed when the matter was called on. Later on, we said that after looking at the nature of the order, we asked you, can you support this order? Tell us how this order is wrong. So we have ignored that court fee part. We wanted you to address us whether this order is a wrong order or a correct order.
In my
I am asking this very simple question
in
on the merit of the appeal.
in my view, as I have challenged the order, particular order, automatically I find there is some defect in the order.
That is your role,
I beg
sir.
your
That is your role. But at least you'll have to convince the
Yes,
bench
exactly.
with the law that this is what you perceive to be the correct law. And merely you think that it is a good case, that does not mean that the bench has to just go by what you think and then pass an order. What for the adjudication has been entrusted upon us? If the lawyer is the only one who thinks that everything is correct, then there's no question of any
beg
judge to come.
apologies. My submission is not from that angle.
That is what you said. In my opinion, it's the best case. And then we'll have to go. I say that show us how best it is. Show us how best it is.
In the Lajima bench, Dr. kindly see in the Lajima bench, that is order passed on 21st December 2023, that the Lajma bench has observed, it further transfers from the case record that certified copy of the degree of the trial court is not been filed with the memo of appeal. Let us consider this point.
We can dispense with. Let us consider.
Very well.
Then
I'm not going.
Tell
And
us.
there is also deficit court fees of.
let us see. We will put from our pocket. Let us see. Then tell me.
As the appellant.
Tell me on merit. Tell me on merit. I want appeal to be argued on merit now.
Yes.
Argue.
Yes.
This order, first thing is whether this order is amenable to be challenged by way of an appeal. Is there any provision for an appeal? Tell me. Secondly, on merit, if you say it is, then on merit, whether there was any infirmity in the order by which the entire suit was dismissed for default. Tell us. Two things. First, right of appeal. Tell us.
Regarding the, if your lordship kindly see, subject to the leave of the court with a kind permit.
Correct.
Now, the point 5 I have stated. The ground on the very particular day.
First question, you have not understood what I say. Whether this order is amenable, capable to be challenged by way of appeal. First hurdle is whether the appeal lies or does not lie against an order dismissing the suit for default. If it lies, if we hold it lies, then second thing is whether the merit such which requires an interference.
Apart from this, apart from the merit of the case, one point I have raising before your lordship. Now, question may arise. While the case has been dismissed for default, I have the scope to go to the order 9 rule 9. But I cannot go there. Fact is that, your lordship kindly see, this is my submission subject to the correction of the court.
Order 9 rule 13, I am conscious. I am conscious.
Order 9 rule 9 also.
I am conscious. We are talking about order 9 rule 9. Tell us.
Under order 9 rule 9, this case is not covered. So once
then this case is covered under what?
So there is no provision in the there is no provision in order 9 rule 9.
What? Why not provision? There is a provision for dismiss for default.
As I aggrieved from the order, as I aggrieved from the order. As I aggrieved from the order.
Then order, if the appeal lies against an order, then you will have to satisfy that this order comes under section 104. This order comes under order 43 rule 1. Tell us from both whether appeal against an order is maintainable.
May I submit one thing subject to the leave of day? If your lordship allow me to deposit the court fee and let the appeal come into the process.
We are ignoring all these procedural part. After looking at the tenet of the order, we are inviting you. Unnecessarily, the appeal will be shown pending. Unnecessarily, we want to dispose of. We want to reduce that pendency. Unnecessarily, we do not want these matters to remain. Tell us, we are ready to dispose of, sir. Bench is ready to dispose of. Tell us.
In that event, your lordship allow me a week time.
What week time? Sorry, we can't.
Very well, I am making submissions.
Sorry.
Now, if your lordship kindly see, what are the grounds I have taken in my appeal? What are the grounds I have taken? Grounds I have taken, learned judge court would have failed to appreciate the sudden sequence of the senior citizen. Or the learned judge of the court would have failed to appreciate the senior citizen and more often become seen than the younger age. Learned would have exercised the jurisdiction so vested in law. Learned court would have failed to consider the respondent have violated the principle of natural justice. Now, subject to one ground I have taken. The learned judge court below failed to consider the respondent have violated the principle of natural justice.
Sir, your application for adjournment was moved by you. Court heard you. Court granted you an opportunity and thereafter passed an order. Is it a violation of a principle of natural justice? I am asking.
I do not get any reasonable opportunity.
What more? Sir, there are two things, sir. Opportunity of hearing is given and then adjudication is made upon recording certain findings. The findings may be correct, findings may be wrong, but that does not mean violation of the principle of natural justice. It was given. Only thing is, order is perverse, order is correct. That is a different aspect. How principle of natural justice will come. You were given an opportunity.
Yes. On the very particular day of hearing,
you were given.
I have make an adjournment petition. Court didn't give any scope without going into
Did
the
you not
context.
move? Did you not say to the court that this is what is there? Sorry,
No,
I
court
don't think so.
simply said, we are not ready to hear anything.
No.
Court will pass the order accordingly on the very in the evening.
Then also the Supreme Court judgment in A.R. Antule's case have to be considered. If I correctly remember, I think the state of Maharashtra versus Haridas Ramdas Nayak, probably AIR 1982 Supreme Court. The Supreme Court has said that if any event has happened in a court, then the appellate court should not hear out the appeal on that ground that this event did not happen. The duty of the lawyer is to approach the same judge where such event has happened and say that it has not happened. Wrong recording.
Yes,
but we can't.
Has been recorded.
Sir, you say no submission. The record does not speak so. The record says that you moved, everything was done. We can't believe the judicial order is sacrosanct so long it is not set aside or recalled. It is sacrosanct. We will believe the judicial officer more. That is what the Supreme Court has also said in that judgment.
Look, if the entire record be called for, that will.
Why should we?
That
The
will
order
unfold
sheet.
the entire.
Order sheet is the very important. There is no minutes of. There is no minutes of the proceedings recorded there in the trial court.
Because
Nothing.
on the very
There's
particular
no provision.
day, reasonable opportunity, reasonable
What
chance.
more, sir? Everything was given to you. No, sir.
Order sheet, it is
No,
being
sir.
order sheet, it is being recorded in such a way.
Sir,
But
you are not aware of the.
happened.
Sir, you are arguing just contrary to the judgment of the Supreme Court. You are arguing contrary to the judgment of the Supreme Court. You do not know, you have not read that judgment. এখানে On the screen, can it come? State of Maharashtra versus Ramdas Srinivas Nayak or Srinivas Ramdas Nayak, whatever. 82 Supreme Court.
Subject to the name of the court. If your lordship kindly say the next ground we have, I have represented, for that the order of the impugned or for that the order impugned passed by the learned additional judge 7th court is based on procedural irregularity. Because that point I have raised on the sense, because a adjournment petition has been given, that has not been taken, and all the papers has been collected and order be passed in the evening. That has happened. That has happened in the court
State
bill also.
of Maharashtra versus Ramdas Srinivas Nayak, probably. Yes, this one is State of Maharashtra versus Ramdas Srinivas Nayak. Probably 82. Yes, you were. Yes, what is the citation? Just give me. Just go down. Means, yes, 1249. Yes, this is the judgment. Go. Scroll. Scroll. Just 1 minute. Just go. Yes. Just 1 minute. Slow. Yes. Just read. When we drew the attention of the learned Attorney General to the concession made made before the High Court, then Sri A.K. Sen, who appeared for the state of Maharashtra before the High Court and led the argument for the respondent there, and who appeared for Mr. Antule before us, intervened and protested that he never made any such concession and invited us to peruse the written submission made by him in the High Court. Then we are afraid that we cannot launch into an inquiry as to what transpired in the High Court. Similarly, you are trying to make us believe. Then it is simply not done. Public policy bars us. Judicial decorum restrains us. Look at the language. Matters of judicial records are unquestionable. This is a matter of judicial records, sir. They are not open to doubt. Judges cannot dragged into the arena. Judgment cannot be treated as a mere counters in the game of litigation. We are bound to accept the statement of the judges recorded in their judgment as to what transpired in the court. We cannot allow the statement of judges to be contradicted by the statement at the bar you are talking about, or by affidavit and other evidence. If the judge say in their judgment that something was done, said, or admitted before them, that has to be the last word on the subject. The principle is well settled that the statement of fact as to what transpired at the hearing recorded in the judgment of the court are conclusive of the facts so stated, and no one can contradict such statement by affidavit or otherwise, or other evidence. While the matter is still fresh in the mind of the judges, to call attention of every judges who have made the record to the fact that the statement made with regard to his conduct was a statement that had been made in error That is the only way to have the record corrected. If no such step is taken, the matter must necessarily end there. Of course, a party may resile and the appellate court, I do not know, per such and such, may permit him in rare and appropriate cases to resile from the concession on the ground the concession was made on a wrong appreciation of law only and led to a gross injustice. Now tell me what? You are saying never happened, no opportunity. He said enough is enough. We will not go by this. What is there in the judicial record? Sacrosanct for us.
If I come into the order of the, I will restrain myself to the contents of the order. On perusal of the case record, it appears that the petitioner was directed to file the statement of accounts regarding payment towards the alimony pendant denied.
Sir, I am asking to you whether appeal lies or does not lie. You are not answering this question to me. Against an dismissal for default, whether appeal lies. I am asking you very simple question. Cross that hurdle. If you can satisfy us, then we will enter into that whether there is anything wrong. Taking that 82 also against you, sir. We are very categorical. You are avoiding, you are going wayward.
No, that is the point.
Tell us.
That is the point. Now, my respected submission so far my appeal is concerned. I beg to apologize for the points which I find that at this stage I cannot come. But so far the rules of natural justice is concerned. That point I have raised also, and that has been at this stage, my lord, finding I do not have any other alternative also.
Why? Why no alternative? I am asking this question to you. The first question is asked whether appeal lies. You are unable to say, you are saying no for other alternative avenue. Let us see what is that, what he has done. Let us see. Yes,
one day time be allowed me.
He has exercised his power.
One day time be allowed.
What?
I will take
Nothing. Nothing. Unnecessarily.
one day
Sorry.
time be allowed.
God,
I will
no.
go through that.
Unnecessarily we
Your
can't.
Lordship. Today I have an intention that only the point is that deficit court fee is set will. If your Lordship kindly.
You started arguing on merit, so we decided, we asked you this question at the very outset.
If your Lordship allow.
No, it is there.
If I am not able to satisfy the court, automatically matter will dismiss. I have nothing to say.
What?
But today time, one day or today time be allowed. And I have the impression that today I will come on to that order of the register. And as it contains, it's a Lajima matter, Milord. I will concern with the Lajima question matter. A date be fixed, Milord, on the particular day. Matter be discussed.
Tomorrow for orders will not go by that, anything more. And pay 20 rupees in the meantime first. Deposit today, 20 rupees. Today go and deposit 20 rupees. Court fees. Tomorrow is second matter for order.
I am learning so many things from this court also.
No. It's not everybody. We are also learning. It's not that we are also not learning. We are learning. Let's call the matter. Yes.
And I appear with the appellant. My lord. That, my lord, appellant before your lordships is a plaintiff in a suit for, my lord, declaration that the defendant is a trespasser and, my lord, recovery of possession. My lord, learned trial court decreed the suit. My lord, the lower appellate court, my lord, remanded the matter to the trial court on the point that the prayer was not made regarding, my lord, right title interest of the, my lord, plaintiff. My lord, the learned trial court, my lord, issued a specific, my lord, framed a specific issue on that point, that whether the, my lord, plaintiff has right title and interest in.
Where is that issue?
My lord, your lordship kindly come to
Trial
the
court's judgment.
yes, your lordship kindly come to the
Where
judgment
is
of the learned trial
that
court.
where he has indicated what are the issues in the suit.
Yes, yes, your lordship kindly come to internal phase, my lord, 5 of the trial court's judgment.
Trial court judgment. Where is a
Issue number three. Issue number 3. This issue has been decided after considering the evidence.
Where is that?
That finding, your lordship kindly come to
issue number 3 at page 8.
Page 11.
No, page 8 it starts. Issue number 3.
A relevant part, my lord.
Whatever.
Page
Let
11.
us see. Now tell us that why appellate court.
My lord, your lordship kindly come to the judgment of the appellate court. My lord, internal phase 6. 6. From the top. My learned trial lower appellate court arrived at the finding that, however, the court is the middle portion.
Where? Page 6 of the internal page 6.
Internal phase 6.
The learned court framed all together. That is, it starts with this 5 issues. It does not include any issue to determine.
Issue has not been, my lord, discussed.
Defendant in the suit property.
My lord, issue was not, my lord, at all, my lord, discussed. Only, my lord.
Just found that the plaintiff said is it. How? It is not necessary because the right title and interest of the plaintiff was there.
Yes.
Then why the legal character of the defendant has to be?
That is the problem. Did not consider the, my lord.
Whether the plaintiff has the right title and interest in respect of the property. That means that if the plaintiff fails to prove, then question of declaring the defendant's right does not arise.
So my submission, this finding is perverse, my lord, without considering the, my lord.
Can you serve and bring? We do not want to keep this matter pending because it is such a small and big issue
your lordship,
that we can dispose of in one go.
Yes, I shall serve, my lord. Your lordship kindly admit this, my lord.
admit, then we will lose our jurisdiction.
Then, my lord, again, my lord, I'll have to, my lord, they are, my lord. My lord, your lordship admit, I shall, my lord, within shortest.
So then we'll have to go before the single bench to argue. You serve, we are just keeping it pending. You serve and come back.
Yes, I shall.
So that we can at least expedite the matter.
Yes, my lord. This can be, my lord, disposed of
And
by you,
this
lord.
will be only for the purpose of substantial justice to be imparted to the parties.
Yes, I
Come
shall.
back. They did not appear even in a injunction matter.
My lord?
They did not appear.
No.
Sorry, in a condonation matter.
No, they did not appear. I saw. Your lordship allowed on that day, they did not appear. I filed a affidavit service.
Serve a further notice upon them. So
Yes, I shall, sir.
just simply adjourned for a fortnight.
My lord, I appear on behalf of the appellant, my lord. I'm led by Mr. Hon'ble Chatterjee. If your lordship may kindly makes it not today and kindly keeps it on Wednesday, my lord.
The 2020 appeal, sir.
Yes, my lord.
Nearly 3 years have elapsed. What are you doing? It has not. It's still at the traveling at the admission stage.
My lord.
What the other peoples will gather that the appeals are not even admitted for 3 years. And you are asking for adjournment whenever it is. I have seen many orders asking for an adjournment. Asking for an adjournment.
I kindly keeps it on Wednesday, my lord. I'll make sure.
No, this can't be done. Even you say that please give me, I have a urgency in the matter. A court is fixing the matter within 15 matters, and you are asking for an adjournment. On mentioning by the opponent, upgrade this appeal and connected application to 115. Again, the same order. First 10 matter. 15, 10. Now, number 2. Who is the advocate on record?
I'm the advocate on record, ma'am.
Argue. What is the matter about? I have never come across with such kind of a second, the memorandum in a second appeal.
It was drafted in a very junior stage, my lord. I apologize, my lord.
What is the matter about?
My lord, the matter, my lord, it is suit for declaration as the plaintiff is the owner of a business, my lord, and recovery of possession along with other consequential relief, my lord. Trial court, I was the defendant, my lord, and the lower appellate court reversed that judgment, my lord. In trial court, it was decreed on my favor.
Then appellate court reversed the judgment. Then how? Oh, that's the reverse.
The judgment of reversal, my lord.
Why? On what ground?
On the ground.
What is the fact?
Yes, my lord.
What is the case made out by you?
My lord, my case is that, my lord, I am a tenant in respect of that property. I have been subletted by the plaintiff. I run a cycle repair shop, my lord. And with respect to that shop, I have purchased all the tools along with the business from them, from the plaintiff, and I'm running the shop by paying a monthly rent
Just
of.
1 minute. Who are you, the defendant?
Yes, my lord.
What is your right in the property? Tell us. What is your right in the property?
My lord, I have been subletted by the.
Have you got a single scrap of paper to prove? Produced it? A single scrap of paper that you were paying 100 rupees as a monthly rate? Show us that you produce a single scrap. Even a license to run a shop does not stand in your.
My lord,
It
the.
appears that you were an erstwhile employee of the, I do not know, the father or the husband of the plaintiff. And after his death, they wanted to close it down, but somebody said that let him. So you were continuing under his authority.
No, no, my lord. After the death of the father of the plaintiff, my lord, since she is a lady, my lord, the shop she
So
couldn't.
she does, but she permitted. There are many proprietors in a business now. You can't say the business can be run through an employee. Where is the difficulty? She can manage. She will not go and repair, but she can definitely manage. What is so? Give us one document.
My lord, I need further
No, nothing. There is nothing. Who is leading? Who is appearing?
My lord, Mr. Aniruddha Chatterjee is appearing.
Where is he? Sorry, can't. Yes.
My lord, kindly give me some time, my lord. I'll come back with instruction with along with Mr. Chatterjee, my lord.
Where is Mr. Chatterjee?
My lord, he's appearing. He's not ready with the matter, my lord.
No.
Kindly keeps it give me one.
Maybe harsh, sir. After looking these matters unnecessarily for adjournments, we do not encourage. We do not encourage.
I'm paying.
No, sir, I understand. Call him. If he come at around 12:30, this much I can give, he'll have to argue. We will not adjourn under no circumstances. Then what is the role of the advocate and record? Only for the purpose of signing the Wakalatnama? He has no other responsibilities in the matter. He's supposed to know the case. He's supposed to place the facts. I understand at the junior stage, you may not know all these nuances of the law. You will gradually start learning. I understand, no difficulty. But at least the facts, something, but we find nothing. Let him come at 12:30, otherwise we'll not. Unnecessarily, all these matters should not be allowed to remain on record. Unnecessarily, these are pendings. Otherwise, we'll proceed. We'll come, we'll dictate at 12:30. Just call at 12:30.
My lord, Mr. Chatterjee, my lord, Mr. Chatterjee did come to court today, my lord.
No, with that. Sorry.
He kindly keeps it tomorrow.
Why he has accepted the brief if he cannot come to the court?
My lord, kindly keeps it tomorrow, my lord.
Definitely. He frequently appears online. It's not that.
The brief is.
I have, at least before us, many a times he has appeared online. Why he cannot appear online? We are permitting him to appear. Tell him to log in at 12:30, otherwise we will not. Wherever he has to argue. Yes, call at 12:30. What is this? Yeah. Is this meaning? Yeah, the word I do not know. Ululates means warrants, but I do not heard. You need to put dates for any different. We have picked out a case not pleaded by either of the parties. Both the parties pleaded on that basis that the plaintiff has 3/4 share and the defendant number 1 has 1/4. Then they ask for a declaration. He has proceeded that plaintiff number of sale and plaintiff number 2 is judicial proceedings initiated under section 440 actions. So this contradiction of mutually destructive proceeding, yes, he has proceeded to dismiss the suit, which in my opinion has pleaded to the plaintiff to complete that. How can you make out a case like that? Of consent. It's a trick case for admission. Sanjeev Mukherjee. This is my handwriting. Okay. Note earlier. Can anybody know this Prosenjit Mukherjee? Anybody knows him? Bar Association room number 5. His mobile number is there. Call him to come. এটা দেখি তো mobile number আছে। Just call him.
Also, extremely sorry, Lordship, court number 39 was start.
This is not expected that you will not appear.
Lordship, this matter was moved earlier. And Lordship, kindly recollect that initially, Lordship, this land in question, the settlemental land belongs to Sitanshu Kumar Datta since deceased. Now, Lordship, the Sitanshu Kumar Datta, Lordship, the expired, leaving behind his wife, Sobita and Mala.
Whether the Court of Appeal below was just, this appeal shall be heard on the following substantial question of law. Whether the Court of Appeal below was justified in affirming the judgment and decree of the trial court solely on the ground that there is a conflict between the right title and interest of the plaintiffs when neither of the parties have taken such point either in the pleading or at the time of an evidence. At the time of an evidence, lower court record, put in the special messenger cost within a week, paper book 4 weeks from date, requisites within a week.
So I file a stay application also.
Before the service, before the appropriate bench.
I beg to appear for the appeal, and Mr. Shijib Chakraborty is leading me in this matter. What happened, due to some difficulties, he's left the court due to his illness. If you kindly keep it day after tomorrow, my lord.
To argue, you are an advocate on record.
Yes, my lord.
So argue.
Kindly, my lord. If on the next occasion, if Mr.
What is
Chatterjee
the
will
suit
not.
for?
It's a suit for declaration of title and the permanent injunction. Declaration of title and the permanent injunction.
What title? On what basis?
On the basis of some documents that has realized. What happened, my lord? The appellate court has dismissed the appeal for the continuous default, my lord.
Where is the judgment of the appellate court?
But it is with the memorandum of appeal.
There is a certified copy of the judgment.
A certified copy of the order passed by the appellate court as well as the trial court. Both I have next with the memo.
Has it been restored? Your appeal is dismissed for default.
Dismissed for not only default, my lord. This is a unique. What happened, my lord? The appeal is dismissed for continuous default. As I presume, lordship, when I will not appear at my absence when the matter was dismissed for that is tantamount to dismissed for default. My lord, here I appeared and prayed for some time, but my lord, the learned trial just said that due to the continuous default, the appeal is dismissed for continuous default. That's why, my lord, we came up with a second appeal.
Where is that sale deed?
But, my lord,
where are those documents which you took back?
That is the exhibit 2, my lord, the partition deed.
Why you did not file it?
But I have said that it is kept with the record, my lord. Later I have found I have taken instruction from the
So,
client.
sir, it says that you have taken it back.
I have taken it back, my lord, as it's
So
reflected,
why you
my
did
lord.
not?
I have reflected. That is the
Why you
contact
did
I have.
not? Why you did not file it?
That is ready, my lord. The exhibit 2.
No.
But I have received the copy, my lord, but it's not eligible.
It says that no, sir, there is a tampering in the original document.
Yes, my lord. That is our contention. That is our contention, my lord. We have contended that the documents has been tampered by the respondent. This is our contention, my lord.
Where is that document?
My
which you
lord,
have
the
taken back?
documents I have, the client has given me the documents which is not completely not eligible, my lord.
No, sir. That was marked exhibit.
Yes, that was marked as exhibit.
You received it back on 10th of November 2010.
Yes, that is
Thereafter,
reflected.
several directions, more than 10 years have elapsed.
Yes, that
You
is
did not
reflected.
refile it. Then
That
what
is-
to do?
Just, my lord, what happened, my lord?
What wrong the appellate court has done?
The appellate court has correctly, my lord, but only things that has to be
No, only thing
taken
will
up on
not do.
merit, my lord.
Why? Exhibited documents, that's the very basis of your title, and that exhibited documents are not filed, taken back by you.
My lord, but
And the trial court has taken note of that.
Yes.
You will not file it.
Yes, my lord.
No, sir, sorry,
with regard to
we
documents
can't permit you to take a court for a ride.
No, I'm not taking.
You have taken a court for a ride. 10 years, the learned judge has recorded.
But
10
I tell
years,
you, the
he has
documents
been
is not in
harping
my
on that.
custody. Documents is not in my custody.
Your custody. You are a
It's not in-
plaintiff.
I have taken instruction from the client, my lord, the original, the
Then who
exhibited,
put a signature?
exhibited documents is
Who
not in
put
my
the
custody.
signature on 10/11/2010?
This is the documents, my lord. This is the exhibited documents. But
I
this
am
is,
asking you, where are the original document which you took it back?
my lord, this is left.
The
my lord,
plaintiffs have taken.
Yes.
It says that it is also detected that on 10/11/2010, all such documents were returned to the plaintiffs.
Father of
You are
the
a plaintiff.
plaintiff.
Sorry.
Yes, I am the plaintiff, my lord.
Plaintiffs.
Yes, I am the plaintiffs.
If you are claiming through your father, then you should know what is what.
That is the
Where is that
difficulties, my
document?
lord. That is the difficulties.
No, then you will have to suffer. You'll have to suffer.
Surely, corruption.
You are taking a plea, the certified copy. There is a tampering, and you cannot produce
I have
the
alleged that
document which you
has
took it
been
back.
alleged by us, my lord. Documents has been tampered. That has been alleged by us.
No, that is what you are saying, and then you are not in a position to give an original document.
That I instructed my client.
Sorry, certified copy has been given.
But he has given me a copy that is not eligible, my lord.
No, certified copy. He says that there has been a tampering in the certified copy. Then produce the original. No, he says that he has got returned. He is not denying such custody, but taking a ground that the appellants want to rely the certified copy for the reason-based noting. But he is saying that by relying the certified copy, he wants to show that there was a tampering in the original. Produce the original. And how long the court will wait for you?
No, my lord. Kindly, lordship, kindly send it back to the remand, my lord, so that
No,
I can.
sir. You produce it here, then we'll send.
Lord, my lord,
You produce the document here.
I will, my lord. Definitely, I will.
Cannot do it like this.
Definitely, my lord, I will. Lordships, kindly give me a week time, my lord. I will instruct from the clerk. I will take instruction from that, and I will definitely
nothing.
produce the
No
original.
instruction. Nothing.
I will produce it, but she has given me only the copy which is not eligible.
Sorry, we can't. The exhibited original document where the seal is there of the judge.
Yes, my lord.
We want that document to come.
I will take instruction, my lord. So far to my
2000
instruction, I have
and it
submitted
is
before your
pending
lordship.
since 2023 when you have filed. February. More than a year has elapsed. You are unable to secure the certified copy. The original document.
Original documents.
1 year has elapsed. You have not produced.
Original documents have, my lord.
Where is the original document? Show us. You have taken it back. More than 13 years have elapsed.
I have the type copy, my lord, because.
Sir, you are appearing in a civil matter.
My lord.
You know that the court cannot look into any other documents unless those are exhibited in the proceedings. You have taken back the exhibited documents.
My lord.
Are you not supposed to file those exhibited documents again? Why you will not file it?
Give me a week time, my lord. I will.
Sorry, we will say to the court that we are saying and say that he will not rely upon those documents,
Sir, I have
nor
relied,
make
my
any
lord.
findings upon
But
those
what
documents,
documents I have
nor
handed over,
will
my lord.
permit you to make any submission on those documents.
But this is the typed copy, my lord. Only, Lordship, kindly give me a week time, my lord. I will produce the original, my
I
lord.
have a
will
very bad word which has come in my mind. I do not think that for the member of the bar I should use it
I apologize before your
in
lordship.
a open podium when we are live streamed.
I apologize before your lordship.
What you are talking, are you realizing what you are saying? Type copy, type copy, type copy. Sorry.
It's the daytime, my lord. I will produce it. 2 days time, my lord. 2 days. I will produce it, my lord. If it is with the client, well, I will produce it.
13 years you could not produce, and you are so sanguine that you will be able to produce within a week.
Right.
Your conduct does not instill a confidence in us that you will be able to comply what you say. The court, appellate court, was absolutely perplexed with this kind of a thing. Very opening sentence here says that this is an appeal of more than 10 years of age. For 10 years, you are unable to produce that document. And you wanted the court to give a show a leniency to you. Only appropriate word for your client is recalcitrant litigant. Come on Monday and show us.
My lord.
It is assured by the advocate and record of the appellant that on the next date of listing, that is Monday, you would produce the original documents which the plaintiffs are stated to have taken back after the same were marked exhibits. Let this matter be listed on Monday as per order.
My
12:30. Go. Yes.
My lord, Mr. Chatterjee is appearing. My lord, kindly gives me not today, my lord.
You argue the matter. You argue the matter. Yes. Argue.
Mr. Chatterjee is appearing in this matter, my lord.
We gave you a time, and we are still open that somebody who want to argue on a virtual mode, we are always permitting.
My lord, the
Despite no
difficulty is
direction,
brief
administrative
is
order of
brief
the
is
Chief
with me,
Justice,
my lord.
still, at least this bench is of the view that we always encourage, if there is any virtual hearing, we are ready to hear.
I humbly understand, my lord. My lord, the brief is with me, my lord.
No, but
Kindly
then
give
how
me
you have
1 day.
engaged him, then that shows that he has not been engaged in the matter. He has not accepted the brief as yet. How can you take an adjournment on his ground?
No, I am
Who
a
has not
chamber
been
junior,
briefed
my
at
lord.
all? Who has not been briefed because the brief is with you.
I am chamber junior, my lord.
No. Sorry. Sorry.
My lord.
No. Tomorrow is a third matter.
Great.
Duto ache na? The third matter.
My lord, I am for the appellant, my lord. My lord, your vision. Your lordship, my lord, instructed me on the last occasion, my lord. There's a
instructed you.
My lord, directed me. My lord, there's a delay, my lord, for the title appeal, my lord, was dismissed on that ground, my lord. The delay was taken, my lord. My lord, the ground of delay, my lord, that was, my lord, taken in the application was that, my lord, the brief was assigned to a learned advocate. He did not, my lord, perform his job. And thereafter, my lord, the matter was filed, my lord, after a substantial period of time, my lord. And for that, my lord, and the learned trial court, my lord.
Where is that advocate?
My lord, I, my lord, served a copy, my lord, of the application on him. My lord, he received it and he called me up, my lord, personally. And he, my lord, denied the allegations against him. My lord, I told him, my lord, that this fell from your lordship and you should be appearing before your lordship. My lord, my lord, after that, my lord, whatever your lordship, my lord, thinks fit, my lord. There's a delay of 643 days, my lord. For that, my lord, the learned advocate.
Where he practices.
In Alipur court, my lord.
Why he did not appear?
My lord, I told him, my lord. My lord, kindly seize my letter, my lord. My lord, he received the copy, my lord. He called me up after that. My lord, from my letterhead, my lord, he found my number, called me up, my lord, asked me about the matter. I explained him in detail, my lord, about this.
Allegation against the advocate is two. One is, first one is very serious. The advocate got his signature in blank paper without telling him what was the purpose he is taking your signature in blank paper. Specifically stated in the section 5 application. Secondly, for 2 years, the advocate had taken the brief before did not return his back. These are the two allegations. First allegation is even more serious. How many days delay?
Well, 643.
Where is that first ground that signature was obtained?
Yes, section, kindly see the section 5 application.
Where is that? Which paragraph?
Section 5 application
It is not annexed anything.
No, which paragraph? Yes.
I'll show, I'll have a copy. Do I copy? No. Yes.
Has he annexed that copy?
No,
No, my lord. An injunction application that is not annexed.
Not annexed. No, injunction, no. Section 5 in the trial court.
My lord, no, my lord. I have only filed an injunction application. In that, I have not annexed, my lord, the document.
Give us that.
Yes,
His application for
I'm-
confirmation filed in the first appellate court.
Copy नहीं है. Copy नहीं है.
Which paragraph?
And only one copy. Applicant, both দেবে না।
না, আমি রিলাই করছি না তো। যে রিলাই করছে সেটা দেবে না?
Welcome, Mr. Chatterjee. Who is this? Mr. Chatterjee. That is the Hon'ble Roy.
Para 18 is one. Yes, para 6 and para 18. Para 6 and para 18.
Subject to correction, my lord, this is not the ground. My lord, this is not the ground for the delay.
6 and 18.
Speak for doctors.
My lord, 18 is the ground, my lord, for the delay. 6 is not, my lord. Subject to correction, my lord.
This is it.
কি করছো? কিভাবে? সার্থকে করছো? বিশাল। এটা সেকেন্ড এখন। আরেকটু ইন্টেলিজেন্ট হতে হবে। বোঝো ব্যাপারটা।
Just
রিট পিটিশন সেকেন্ড অ্যাপিলের তফাৎটা বলবো, কোনটা স্বার্থকে কেন থাকে সেটা বুঝুন। স্বার্থকে যাতে যাদের স্টেট অফ ওয়েস্ট বেঙ্গলের অফিসাররা ওরা পায়, ডিস্ট্রিক্ট ম্যাজিস্ট্রেট, যারা যারা পার্টি, এটা তো প্রাইভেট পার্টি, অসিত স্টেটমেন্ট, তো সেকেন্ড অ্যাপিল।
What is the order? It's a dismissal of section 5 or withdrawal?
Dismissal of section 5.
He is talking about many things.
No, my lord, what has been done initially, my lord, what happened, my lord, they had filed the appeal before the Alipur court, but the jurisdiction it will be in Paripur court. Now, my lord, that appeal was withdrawn. Then, my lord, he went to this advocate, he kept, my lord, the order, withheld the file for 2 years, then did nothing. Even if the lordship will be surprised, kindly see another application. My learned friend has not annexed anything, I'll be, my lord,
withdrawal also objected to the
application
specified. That has been not yet
even he has filed an application before the
before the 2009. Three.
Yes, kindly see, my lord, this application.
Visited the chamber. Should I be
তারপরে গিয়ে বারুইপুরে ফাইল করো।
আমার
দিয়ে দাও দিয়ে দাও।
मेरे को तो समझ में नहीं आया।
What you really wanted to say is not it cannot be ascertained from this application for condonation of delay.
Well,
What you really wanted to say, what has happened?
Well, paragraph number 18, my lord, more or less, my lord, says
Paragraph 18, nothing, we could not make a head and tail from there.
But, kindly see, my lord, this application.
12/3/2015 order.
No, application. What happened, my lord? Initially, the appeal was filed before Alipur court. My lord, withdrawal application is also there in that bunch. Kindly see the 151 application, para 7. They did not want to withdraw from Alipur court. My lord, I'm surprised by their conduct. Once they say, my lord, Alipur court do not have jurisdiction, they want to withdraw. Then when the advocate withdrew, serious allegation against the applicant. Kindly see 151 application, paragraph 7. It was not their instruction given to withdraw the appeal. Well, all allegations are directed to that advocate. Kindly see paragraph 7 of 151 application.
These are all the part of the record.
These are all part of record, certified copy.
They're all part.
Kindly see 151 paragraph 7.
Clear the course of records. What you have done?
My lord, conduct has been poor, my lord. I cannot, my lord, defend this conduct, my lord. But my lord, kindly considers, my lord, the person himself, my lord, the litigant before your lordship, my lord. Lordship knows, my lord, how, my lord, applications are, my lord, taken
Very
care
bad
of.
way of.
My lord, this, my lord,
Yes, for orders at fourth, we'll dictate it. Hey, quite a 42. Hey, कागज भी अपना
my lord, only my lord considers one aspect, my lord. My lord, the learned advocate, my lord, was given a chance, my lord, before your lordship, my lord, to defend his conduct, my lord. My lord,
But he said that he is flatly denying that there was any lapses. Then what he will do?
over me to telephone, my lord.
Whatever.
But my lord,
Whatever.
after your lordship's, my lord, direction, my lord, I served upon him, my lord, so that my lord, he may, my lord, appear before your lordships, my lord.
I'm filing 2 copies of 2 judgments, my lordship may consider.
What judgment?
Supreme Court has categorically said advocate, allegation of advocate, my lord, that has to be construed very strictly. My lord, not, my lord, as casually, my lord, as my learned friend has leveled. I copy the collect.
My lord.
But 13, the document, I shall get it today. The translation officer.
How many
Today.
times?
But Mr. Saman's chamber, he told me to just in the morning he will get it today.
Next.
Your Lordship, Mr. Joyanta Shamanta appears for the appellant in this matter. He is presently appearing before another bench, Your Lordship. I'm praying for not today.
No, sir. No, madam. You do it. You are advocate on record.
No, Your Lordship, I'm not the advocate on record. I'm his chamber junior, but I am not in this matter. I do not even have the brief with me, Your Lordship.
Who is the advocate on record? Days.
Your Lordship, Mr. Joyanta Shamanto is the advocate on record himself.
In the event the defects pointed out by the department is not cured within a week from date, the appeal shall stand dismissed.
Obliged, Your Lordship.
Lordship, I'm from the petitioner. Lordship, senior, kindly adjourn the matter.
For the responsibility, please. Who is the advocate on record, madam?
MD Abdul Rahman. He is not.
Where is he?
Ma'am, for the Lordship is a religious purpose, is in a subrat, he is not coming today.
And who is the senior?
Huh?
Who is the senior?
Lordship, he is a friend of my senior advocate.
What is his name? Who is?
MD Abdul Rahman.
He is the advocate on record. He has engaged any senior?
Yes, Lordship.
Who?
Chittaranjan Chakravarti.
Where is he?
So Lordship, he is also in another court.
Call him. He is interested to do the matter. He can do the matter.
Okay.
Where is the difficulty?
Okay.
Call him.
Okay. Great.
Pass over.
$16 I'm for the appellant. Madam, for the appellant, my lord, there are some defects, my lord, her classification and my lord, the arrange of the copies, I think the decrease and
We can take care of
my
that.
lord.
Who are you, the plaintiff or the defendant?
I am for the defendant appellant.
Judgment of affirmance or reversal?
Judgment of reversal.
Reversal.
Yes. My lord, the suit was dismissed.
Dismissed by the trial court?
Yes.
Now
Thereafter,
appealed by the-
appeal allowed.
What is the nature of the suit?
A declaration of tenancy right, my lord.
Declaration of
Tenancy rights,
You are claiming to be the owner of the property.
my lord.
Why the appellate court allowed it?
Because my lord, the suit but kindly come to the judgment of the suit court.
No, it's not. Appellate court. Show us why the appellate court has granted or reversed the judgment. Why? On what ground?
In the plaint, my lord, the plaintiff state that they are the tenant under the defendants.
Correct.
But they are not tenant under the defendant. In the evidence, they showed they were the tenant under the predecessor of the defendant. So in the appeal court,
what is there? It's the one and the same.
my lord, the appellate court went beyond the pleading, my lord. Evidence was laid, which is beyond the pleading. That's the question, my lord.
No.
My lord, kindly, my lord, I have the plaint, my lord, with me.
Sir, one thing is that the plaintiff claims to be a tenant
Under the defendants,
in the pleading.
my lord.
In the evidence, it says that under the predecessor in interest of your, means you are a subsequent purchaser or you derive title.
I derive title, my lord.
By way of inheritance.
My lord.
What?
I derive title, my lord.
By
By
way of
way of inheritance,
inheritance.
my lord.
So, how it makes a material difference?
Because, my lord, they are tenant under the defendant. There is no rent receipt they filed. There is no rent receipt. They filed rent.
After all, they claim that they were the tenant under your predecessor.
My lord.
Maybe father or
And even, my lord, in the rent receipt, it was signed by another person who issued the rent receipt on behalf of my predecessor. It was shown.
So whether that gentleman was called as a witness?
But the gentleman was called as a witness. And he, my lord, assured that he was given authority to issue the receipt.
Has he produced any authority?
No, my lord. One. No, my lord. No authority was shown. Give.
Did you put any question to him during the cross-examination?
My lord, from the deposition, my lord, it is not clarified, my lord. My lord, this is the deposition of the PW2. This is the two copies only. আলাদা করছে, সব আলাদা করা আছে। Dipankar Shah is the plaintiff here. Under whose signature the rent receipt was. And he claimed, my lord, he was one of the co-sharer of the properties prior to 1998. And before 1998, the property was a joint property. And thereafter, partition was there. And after 1998, my lord, my predecessor in interest is the owner of the, become the owner of the property of that portion.
And then he started collecting rent through another gentleman, Sunil Chandra Saha,
Sunil Chandra Shah is my predecessor, man.
your predecessor. And who is a Sudhanshu?
My father. The Dipankar, the appellant's father is the Sunil Chandra Shah. No. My lord, Sunil Chandra Shah, yes, my predecessor. My lord, my predecessor. The appellant's predecessor is Sunil Chandra Shah. Yes.
And who is the owner? Sunil Chandra Saha.
Sunil Chandra Shah.
Sudhanshu was issuing a rent receipt.
Sunil Chandra Shah never issued rent receipt.
Sudhanshu was
Sudhanshu, my lord.
was issuing
Yes.
a rent receipt.
Yes.
What is the relation between Sunil and Sudhanshu?
They are the brothers.
Full blood brothers.
Yes.
And these rent receipts of which year?
Rent receipts were, my lord, prior to 1998, which was exhibited from the Right, exhibit was 10 rent receipt issued by Sudhanshu Shah and 6 rent receipt issued by Sunil Chandra Shah.
So even if
My
the
lord.
Sudhanshu issued rent receipt
My lord.
on behalf of your father,
Yes.
in Sunil Chandra, but that was for the period for a period when the property was not partitioned.
My lord.
So naturally, the Sudhanshu was one of the co-sharer.
Yes, that was there.
Later on, he sold his share to the defendant number 1, you. Sudhanshu later sold to you.
Yes.
So if the tenancy was there when the property was unpartitioned,
Yes.
does it evaporate on partition?
But my lord, the plaint clearly states, in the plaint clearly states that
Forget
they were the
about it.
tenant
The
under defendant.
evidence, the documents which are forthcoming,
Yes.
that document will, suppose if there is a variance in the pleading and the documents which are produced, there is no difficulty in this regard. The sanctity or the genuinity of the document is not at stake.
Yes.
Then which will prevail? Is the documentary evidence that must prevail.
Yes. It's documentary evidence.
Only thing is, the moment they accept you as a landlord, then they are stopped from challenging your title under section 116 of the Evidence Act.
My lord.
They cannot challenge because they have admitted. But at least the tenancy does not get effaced.
My lord, kindly, my lord, I'm reading the judgment passed in the title suit, my lord.
Sir, I am asking you, sir, rent receipts were produced.
Yes, rent receipt are produced.
There is an undisputed position that the rent receipt was issued and signed by the Sudhanshu.
But in my written statement, my lord, we stated
the Sudhanshu came as a witness.
Yes.
Sudhanshu said that yes, these are my signature. I have issued the rent receipt.
Yes.
For and on behalf of Sunil Chandra under an authority.
My lord.
But it appears that this rent receipts relates to a year when the property was unpartitioned.
My lord.
Suppose if there was no authority, at least the Sudhanshu has issued the rent receipt.
My lord. Yes, yes.
Admitted position, I mean undisputed position, not admitted, undisputed, because Sudhanshu has proved that. So he was one of the co-sharer at that point of time.
Yes.
One co-sharer can create a tenancy, there is no difficulty.
But it is stated, my lord, on behalf of Sunil Chandra sir, my lord.
I'm just talking about the proposition of law.
My lord, my lord.
So if he can, then probability is that if he has said that on the basis of an authority and your father during the lifetime never raised any objection to it.
But my lord,
Now tenancy, if it devolves, then in that event, what will happen? You acquired the right from your father by way of inheritance,
my lord.
and by virtue of a sale, you acquired the right of Sudhanshu as well.
Sudhanshu as well.
So in both the cases, why not? He remained as a tenant.
But my lord, he was given.
You have said a licensee, but he has proved his possession prior thereto.
Yes, he was a licensee. He was under permissive possession.
But
yes.
He has proved that from the day when you claimed is a permissive occupation, he is already having a red receipt. Then what remained?
No, my lord. Then my lord, I'm coming to the appeal, the appellate judgment, my lord. On page number 5, my lord, which starts would fall with the allotted portion of any other portion. So this not a believable story. Yes. Well, kindly come to the decision which reason page number 5 of the appellate court judgment.
We will provide a decision for that. Don't worry.
Well,
we will provide a reason, the decision or findings.
I am fortified by a judgment of the Honorable Apex Court, my lord,
Sure.
that beyond the pleading beyond.
We are conscious.
Yes.
And we are also, when you have cross-examined
yes.
on that point, then it becomes more academic. The court shall not rely any evidence which is not there in the pleading.
My lord.
But sometimes if you cross-examine knowing fully well that this is the ground you have to meet, then it becomes more academic. This concept becomes more academic.
My lord, here my
line of judgments you have not brought up the Supreme Court?
Yes, that judgment, my lord, what I am relying, my lord, I
am saying that this is also a judgment of the Supreme Court.
My lord, that judgment I
issue, no issue, parties well aware that what is there and what is beyond the pleading. The pleading says that he is a tenant under you.
Under the defendant.
Under you.
Yes.
Admittedly, he has to be under you because your father was a landlord and upon his death, he can't remain a tenant under a dead person.
But he, my lord, did
you
not
succeeded. State. Then he becomes a tenant under you.
He did not state, my lord, that the tenancy started from there.
There is a distinction between a pleading and a proof.
Yes.
If the evidence is required to be pleaded, then there is no question of giving an oral evidence. He says that he is under you. In what capacity he has come under you?
Yes.
He has proved that your father, in fact, inducted him. And then, since you inherit the estate of the father, so he became a tenant under you.
That is the reason, my lord, the appellate court judgment is given.
Absolutely correct. This is what the law is. So where is the variance? That you can't produce. You have said that you are a tenant under me. You can't produce any document that you were a tenant under my father beyond pleading. I am really, is a surprising for me.
My lord, kindly see, my lord, the plaint, my lord, I'm showing for your worship.
That is what you want to say.
Yes.
So is it a correct way of doing it? Something which is absolutely foreign and alien, something which really goes counter to what you have pleaded. But here, he's tracing your title in this way. Can he not prove it?
But the learned appellate
That
court,
how he became, only thing is how he became a tenant under you. Can he not prove it? Can he not? I'm just asking.
he has not stated in his plaint.
It's not necessary. He said that I am a tenant under you.
Yes.
Then in an evidence, he can definitely prove that how I became a tenant under you.
And my lord, he has not produced any rent receipt which I issued.
Not necessary. That may be a case of a default that he has not paid rent to you.
Yes.
Go. Whether the tenancy evaporates mere on a non-payment of rent, I have to understand. I will be very happy if you can convince me this law. If it becomes a law of the country, perfect. No difficulty. We'll accept it.
I'm coming tomorrow, my lord.
No, sir. Nothing. Nothing.
I'm coming tomorrow, my lord.
No, it's not that. Not that. Unnecessary. Sometimes the bad case you will have to digest. I understand. You have argued successfully, but what you can do? A lawyer is supposed to argue both the good cases and the bad cases.
Even then, my lord, I may be given the
Embrace the
opportunity.
bad case. Don't try to linger on.
But even then, my lord, I
Then
may be
it
given
is
the
my
opportunity.
fault because I am too interactive.
No, my lord,
I express my mind.
But that is,
and
my lord,
that gives an impetus for a lawyer to get an adjournment.
No, my
That is
lord,
the
I'm
whole
not
difficulty.
getting.
Let us come back and dictate it. Dictate it. Yes.
Item 15, my lord, Mr. Rahman is the advocate. He has some rituals in the house, my lord, at Ompia. His
You
wife
are
died.
senior, sir. Do the matter. You are senior.
No, my lord, he requested me to do it on Wednesday.
No.
And an application not with me, my lord.
What is an application?
Order, there is an application I find there, my lord. That is not
Unless the
also with
appeal
me.
is admitted, sir, application has no value.
My lord, let it be on Wednesday because
If it is admitted, then
then
if
let
it is
be
not
okay.
admitted, then
He will be advocate on record, my lord.
whatever you will be taken care of by him.
I have taken
Don't worry.
consent of the other side, my lord.
No, whatever. He will take care of your.
Let it be on Wednesday. My request, my lord. That is, my lord, because my lord, he has to do some performance due to death of his wife.
No.
Yeah, that is, and
We are not.
on Wednesday.
When that performance will be over?
My lord, today he is doing. My lord, tomorrow is some poor man will be fit. Wednesday I'll do it. Wednesday I'll do it. 15 months.
Not this week, then. Do it. Let him come.
15. Get.
Or it may submit for it.
Now
Well,
I will not say anything. You complete?
No, your lordship, my lord, it is my privilege, my lord, to
Yes.
appear with your lordship
Yes.
and my lord, whatever fault from your lordship, my lord, that is my for learning. Well, this is the plaint, my lord. I'm handing over the amended plaint. Let's kindly have a look. But the first line of the plaint says the plaintiff is the tenant in respect of scheduled premises under defendant number 123 on monthly rental ₹80. According to the Bengali calendar year, the plaintiff is the tenant for a long time. The defendant took rent regularly. Out now, suddenly, defendant number 123 stopped taking rent from the month of Ogran of 1411 BS. Thereafter, the plaintiff sent rent by money order on several occasions, but which were refused. But nothing has been stated that he was the tenant inducted by my predecessor in interest. Thereafter, after his death, the present defendants, who is the plaintiff here, appellant here, has become the landlord and they are paying. They clearly stated that the defendant took rent regularly. We never took rent regularly, my lord. And my lord, they, in the prayer, they prayed for the decree declaring that the plaintiff is a monthly tenant under defendant number 123. But that story, which is stated in the appellate judgment, is not stated in the plaint here. So, my lord, no rent receipt, anything has been adduced by the plaintiffs to show that they are continued to be the tenant under defendant number 123 in their case. And well, no document was produced by the plaintiff also to show the relationship of the defendant.
Not filing a suit. He's that's the delivered direction to give the connection to the suit filed up here. That he can use the control. Then approach.
The factum of relationship between the tenant and the landlord was not shown clearly in the plaint. Or premises tenancy act, my lord. This is one copy I have.
I have. Don't worry. Oh, I was just thinking about 1956 Act.
56 Act.
It's not exclusive. No suit prosecution Section 7. Exactly. 1957 Act and came into effect in 2006. One violation, then this will be covered. Special quantity and people suffer the defects. Take time. শক্তিশালী করা তার এখানে আছে সাক্ষীটা আর দুটো আছে उसमें पावर का कंट्रोल
But in the play, they have not stated that when they were inducted, he was inducted. So the entire story, Mallet, they have made up in the evidence, Mallet, which was not, Mallet, stated in the play. The statement made in the evidence, which is beyond the pleading, Mallet. Mallet, may I hand over the examination in chief of PW1, Your Lordship? আরেকটা কপি আছে আরেকটা দুটো কপি আছে So the one copy, Mallet, attach. Yes, this one.
Yes. Asha. Asha. Signature. I also used to put my signature on the show to the these are the notebooks contained now. It's in relation to the seat of the my signature along with it, the section you admitted.
I handed over the evidence of PW1. And in page number 2, my lord, that I am filing certain documents today. These are 2 rent receipt issued by my favor by Shudhanshu Shah on behalf of Sunil Chandra Shah. The same is marked as exhibit such and such. There are 6 rent receipts issued by my favor Sunil Chandra Shah.
These were marked exhibit without objection. Otherwise, your objection would have been recorded then and there. If you do not raise an objection, can you now take at the plea at this stage? I'm asking.
Yes.
You have not.
The objection was not given.
veracity
That
and
is, that is true on from the record, man.
Should by Sunil. I favor by those are marked.
Well, as I'm being instructed, my lord, I'm instructed, my lord, at the time of my lord, this cross examination, my lord, my client was in jail. It was instructed, but that is not on the record, my lord. That is not on record.
Sorry.
My
Then it is also beyond pleading.
And my
You
lord,
are
I know.
taking the
Just
plea.
I'm just clarified myself before your lordship.
Nothing, sir. You have
But
you admitted all those. Even your father's rent receipt, you have admitted you did not raise an objection that it was not a signature. Otherwise, your objection would have been recorded then.
My
And
lord,
there.
that is not recorded here.
And
my lord,
after objection or something, I can understand. No, sir.
And my lord, I relied upon judgment, my lord, kindly.
Say that what it says.
My lord, I'm handing over 1 copy. I'm reading, and thereafter, I'm giving a second copy. Paragraph 7, my lord. It was reported on 2003, volume 4, SCC, page number 161. Paragraph 7. Such as regards the plea of subtenancy argued on behalf of the defendants by the learned counsel, first we may note this plea was never taken in the written statement. It was a written statement. The way it has been put forth now, the written statement is totally vague and lacking the material particular on this aspect. Well, it was my case also. This is nothing to support this plea except some alleged revenue entries. It is settled law that absence of a plea, no amount of evidence laid in relation thereto can be looked into.
Have you seen that when you cite a judgment, then there must be some facts which you should say. It was a case where a person claims title by way of an adverse possession. A plea was taken that no, it was he was inducted as a subtenant. A claim of subtenancy, which is just contrary to a stand of an adverse possession. And then it says that you did not plead that you were a subtenant. You will not be permitted to take. This is a case of an alternative nature. That even if I fail to secure the title by way of adverse possession, at least I have got a protected position as a subtenant. That was the case. Here it is not a case.
Not a case, my lord. But my lord, the induction and thereafter.
Not. His induction is immaterial. Because the induction is admitted by you. You said that he is under the permissive occupation. What does it mean? That he is there.
He is there. Possession was there.
No, possession is not. That is the distinction between a tenancy and the licensee.
Tenancy, yes.
What is the first principle distinction?
But tenancy and licensee means, my lord.
What is the first distinction between these two?
That is, my lord, any written consent?
No. The first important thing is parting of an exclusive position.
Parting of exclusive.
In case of a licensee, the position remained with the licensor and he has simply permitted to occupy or to enjoy. But the position retained is by the licensor. In case of a tenancy, it is a position which is given
But that is
in
written.
lieu of an enjoyment. That's the fundamental distinction between a licensee and the tenancy.
But that is,
So if you admitted that you have given a position, then it's an admission is that you have created a tenancy.
my lord, it is stated, my lord, in the written statement, my lord. May I hand over, my lord?
It's not necessary. Permissive. You have said the permissive occupation.
Yes, permissive position.
That's all.
That is
You could not prove. He has proved his position prior thereto. Have you disclosed when you have permitted him to occupy?
Yes, that is.
What is the date
Which is
in your written statement?
yes.
Bangla.
Something 37. Written statement. My lord, I have in Bengali, my lord.
What do you think?
আরেকটা আছে my lord, in page number 2 of the written statement, paragraph 3, 4, 5, 6, 7, প্রকৃত বৃত্তান্ত, নালিশি প্রেমিসেস অত্র দখলকারী বিবাদী হইতেছেন, প্রেমিসেসে 3 নম্বর বিবাদী কোনো সত্ত্বাধিকার নাই।
এবং that
মানে 3 নম্বর বিবাদী অত্র মোকদ্দমায় অনাবশ্যকীয় পক্ষ হইতেছেন।
So you are saying that a misjoinder of the party?
Yes, yes.
So
নালিশি প্রেমিসেস যে হোল্ডিং এ অবস্থিত, সেই হোল্ডিং এ 1 নম্বর বিবাদী চানাচুর তৈরির কারখানা থাকে, আছে। প্রকৃতপক্ষে নালিশি প্রেমিসেস ওই কারখানার সংলগ্ন একটি ঘর, is beside the
right, adjacent to a karkhana.
yes,
Anyhow,
yes,
what
বাদী
নালিশি
নালিশি প্রেমিসেসে
premises-এ
কশমিলকানেও বিবাদীগণের অধীনে ভাড়াটিয়া ছিলেন না বা নহেন।
নহেন।
Yes.
নহেন বা নহেন।
Never,
Never.
never, never,
See,
never.
Then
বাদী নিজেকে নালিশি প্রেমিসেসের বিবাদীগণের অধীনে বাংলা মাস অনুযায়ী প্রদেয় মাসিক 80 টাকা
that is
ভাড়ায়
what denied the claim
yes,
of the plaintiff.
denied my lord.
Then
প্রকৃতপক্ষে বাদী নালিশি
premises-এ
প্রেমিসেসের
1 নম্বর বিবাদীর হইতে then
অনুমতি দখলিকার ছিলেন,
ছিলেন।
পারমিসিভ
Then I know ছিলেন কবে থেকে
that is not written, my lord.
written. Then
It's not written.
বাদীর বিবেশ অনুরোধে 1 নম্বর বিবাদীর নালিশি প্রিমিসেসে
মিষ্টি তৈয়ারি করার কারখানা হিসেবে ব্যবহার করিবার অনুমতি দেন।
দেন।
প্রকাশ থাকে বাদী 1 নম্বর বিবাদীর বিশেষ পরিচিত ছিলেন। পরিচিত ছিলেন।
That's known to them.
Yes, well acquainted with them. পূর্বোক্ত অনুমতি দানকালে বাদী 1 নম্বর বিবাদী প্রয়োজনে নালিশি প্রেমিসেস খালি করিয়া ওই প্রেমিসেস খাসদখল 1 নম্বর বিবাদীর অনুকূলে ত্যাগ করিবেন বলিয়া 1 নম্বর বিবাদীকে প্রতিশ্রুতি দেন। There is a promise.
It's a promise to vacate. I know.
To vacate, yes.
I can read faster than you.
বাদী
সহিত
পূর্ব পরিচয় থাকায় এবং বাদীর দেওয়া প্রতিশ্রুতি বিশ্বাস স্থাপন করিয়া 1 নম্বর বিবাদী প্রায় 20 বছর পূর্বে।
The question is that
20 years.
What it gathered is, it is the defendant number 1 who has permitted the plaintiff to remain in permissive occupation. Correct?
Yes.
If he can prove that he was there before defendant number 1 could acquire title, does it not belie your stand that you never permitted him to occupy?
But
he was there in occupation prior thereto, if he can prove it, which he has proved, because you derived title from your father who died from the PW2 in 1988.
Yes.
Before 1988, you did not have any title in the property because you inherited it. And inheritance comes after the death of your father.
Well, it's suit file 2011.
I'm asking you, sir. I'm asking you.
Yes.
So,
Yes.
you said that he is known to you, and then you have permitted defendant number 1.
My lord.
You can permit when you have a title. Is
Yes,
it?
when I have title.
If it appears that his position was there prior to your story of permissive occupation.
Well, it is 20 years back. And 2011, the matter was filed.
Sir, he has shown the rent receipt of 1983-84. Your father died in 1988.
But I
So
said
before 1988, I can understand that from 1988 you have permitted him. But if he can show that he is there in 1983 also, then the question of permissive occupation, is it believable story?
But he had stated, my lord, 20 years back, prior to 20 years. That means from 2011, if we go back to 20 years
Sir,
back,
I can go more.
1991, my lord.
I am going in 1988.
Yes.
Let us go.
Yes.
Extreme case of 1988 because your father expired in 1988. Then you acquired the title by way of Section 8 of the Hindu Succession Act. You became the owner. And you said that you permitted him. So even if I take it in 1988, you permitted him. But he is in possession. He has proved that he is in possession since 1983. He has issued a rent receipt without any objection.
Yes.
Then what remained?
Without any objection.
Your story is wrong.
Well, that objection was not given, but my
It's
point.
not. Then what is the meaning of? Then under the
20
rule of
years,
evidence,
well,
sir, we are holding an academic class for that. You are asking a question. I think the better answer would be if you read Evidence Act, you read the Code of Civil Procedure, you will get answer.
No, but I'm asking myself, Malad, 20 years back means 2011 to 1991. If permissive possession was given in the year 1991, I have been the owner of the property since then. So, Malad, in the evidence, Malad, no objection was put at the time of adducing those.
Are you not understanding, sir, what is falling? Have you got any idea about the tenancy law?
Yeah.
It does not appear to be, with deepest of respect.
Even after termination, if possession continues, the tenant.
No, this is not a case, sir. That is why I'm saying you have to make you should know the distinction between a tenancy
and
lease and a permissive occupation means a licensing. You will start from Associate Hotels judgment of and versus R.N. Kapoor from 1954 or 55, if my memory goes right. You will find the Supreme Court has decided. Even you will get it in Delta International Limited of the Supreme Court judgment, which is of our High Courts. It originates from our High Court, Delta International.
Delta International.
Even you can get a silver line forum judgment subsequent thereto. All these judgments have held that what is the distinction. Please consider. Forget about their case. You said that they can't. What about yours? You have to prove your defense.
Yes.
You could not prove your defense.
I have not put my evidence, my lord.
Because you say that you permitted him as a licensee. It appears from the document, which is marked as an exhibit, that his position was prior to what you have said.
20 years back.
Then it says then your story of giving him a permission is absolutely false. Can you succeed on a falsity?
No.
Can't.
No.
Then when both the parties have come up with the story, then the court has to decide on the basis of what you have taken a stand, what he has taken a stand, and what the evidence comes. Which is, I would say, impeccable evidence that comes. You are citing where there was a complete new story that was set up. But anything which is linked with this stand, can he not? What is the purpose of this evidence to be led by the parties? What is the purpose of cross-examination, right to cross-examination? There are several provisions under the Evidence Act which says in a cross-examination, you can put many questions. In the examination in chief, it says you can't put a leading question.
Yes.
What is the purpose? Purpose is I can give an evidence which would corroborate, if it is taken together, what I have pleaded in my pleadings. And his pleading is very clear that he is a tenant under you.
But well, two things
He
only.
never said inducted by you.
Yes.
Had it been, I
Yes.
would have understood.
Yes.
He never said inducted by you. He simply said he is a tenant,
Tenant
under
under.
you. And definitely he can say how he became a tenant under you. Can he not?
But he has not stated here in the.
It's not necessary. Then every plaint has to contain the evidence. Is it a rule of pleading?
No.
Then,
That is not.
then hey, sorry, sir.
But I have tried.
No, that is my, I would say, shortcoming, because I feel whenever the lawyer, more particularly the junior member, when he comes, so he must be given an opportunity. At least he must have the sense that what I wanted to say has been communicated to the bench. So I never shut it down, but try to make him understand, so that at least he will enhance something. So I don't think so. Although the instant second appeal is filed against the judgment of reversal, against the order of judgment of reversal, yet we invited the counsel for the appellant to make a submissions on the legality and or irregularity of the judgment passed by the first appellate court. We hasten to add, as we perceived in course of dispensation of justice, that and a notion has percolated in the mind of the members of the bar that the moment the judgment and decree of the trial court is reversed by the first appellate court, it is a fit case where the High Court should admit the appeal, the second appeal, filed under Section 100 of the Code. The language employed in Section 100 of the Code does not percolate such sense, semicolon, even in case of a reversal of the judgment, it is imperative on the part of the High Court to find out whether the case involves substantial question of law. We do not thus find any fetter on the part of the High Court in declining to admit the appeal filed against the judgment of reversal if it does not involve substantial question of law. Stop. The genesis of litigation can be traced out when the respondent face the disruptions in supply of essential services attached services and or amenities attached to the alleged tenancy, and approach the court for declaration of tenancy right, and consequently the release in the form of permanent/mandatory injunctions. It is a specific case of the respondent that he is a tenant in respect of a suit premises under the appellants at a rent as disclosed therein, and also claimed to have paid rent, but alleged that the rent receipts were never granted by the appellants. Next one. The appellants took the stand that the respondent was under permissive occupation at the behest of the appellant number one, as he was known to him. The defendant number one is the appellant number one here.
Yes.
As he is known to him. And now is known to him with the condition, as he is known to him, with the condition that as and when as and when he is requested to deliver the possession, he would comply such requisitions. Such being the sum and substance of the respective stands taken in the pleadings, the parties went into trial and adduced evidence. The respondent, respondent's first witness disclosed several rent receipts purportedly issued by one Sudhanshu Sekhar Saha and Sushil Chandra Saha for the year 1983, 84 and 84 and 85. Which were marked exhibits as Exhibit 1 and 2 series without any objection. The said witness also produced the trade licenses issued by the concerned municipality, which was also marked as Exhibit 3 series. The aforesaid documents were produced in order to show that initially initially he was inducted as a tenant in respect of a larger premises, and the rents were collected by the then co-owner, and after the partition is effected amongst the co-owners, the rents was collected by not only by one Sudhanshu Sekhar, Saha, but the father of the petitioner, the present appellants as well. And therefore, the story of creating a permissive occupation is concocted for the purpose of defeating the claim of the petitioner. The first appellate court relying on those rent receipts, held that the tenancy of the respondent in respect of the suit premises, having established, the judgment, the trial court has committed serious error in dismissing the suit. The counsel for the appellant takes a plea that the evidence which is beyond the pleading cannot be looked into by the court, and therefore the findings made by the first appellate court is perverse and place reliance upon a judgment of the apex court in case of Bondar Singh and others versus Nihal Singh and others, reported in 2003, volume 4, SCC, page 161. It is thus submitted that the moment the respondent categorically asserted in the plaint that he is a tenant under the appellants, he is precluded from adducing any evidence that his tenancy was created by the father of the present appellants, and to that effect, the evidence adduced by the respondent should not be looked into. Before we proceed to consider the aforesaid point as before us, it would be proper and profitable to consider the ratio of the decisions rendered in Bondar Singh and others supra. In the said case, the plaintiff claimed title by way of adverse possession. To stop. Initially, the land was owned by one Fakir Chand, who was the predecessor of the defendants therein, and subsequently the said owner sold the same to one Tola Singh, the predecessor in interest of the plaintiffs, by an unstamped and unregistered sale deed dated 9/5/1931. Pursuant to the said purported deed of sale, the plaintiffs claim to have taken possession and remained there uninterruptedly, continuously, and in hostility, and in hostile hostility, not in hostile, and in hostility. I was not getting that one. However, the defendants therein denied the position of the plaintiff, and being such an issue, an argument was sought to be advanced at the behest of the defendants therein, that the plaintiffs came into possession for a brief period as Shikmi, 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 that is subtenant, when such plea was never raised in the written statement. In such perspective, it was held, Bole, quote paragraph 7. Of the said judgment. This is Bondar Singh. It is no longer it is no longer res integra that the pleading must contain the relevant facts and does not require the evidence or the law to be pleaded. It is a material fact which, if proved, would lead to a conclusion in favor of the either party, and it admits no ambiguity that anything which is dehors such pleading if raised, the court is not supposed to look into the same. The case which appears to be unconnected and or unrelated with the defense taken by the either of the parties, with the court cannot permit a party to adduce evidence to adduce evidence thereupon, as the foundation thereof is lacking. Precisely such principles of law has been laid down in the above quoted decisions, where in order to defeat a case of an adverse possession, a plea of a subtenancy for a brief period was sought to be as without any foundation in the pleading. Full stop. The ratio is to be culled out on the basis of the facts involved therein and should not be applied in an abstract manner. A little difference or an additional fact may invite a completely different judgment, and therefore the court, while applying the ratio, should see the parity of facts. Full stop. In the case in hand, It is a specific case of the respondent that he is a tenant under the appellants. It is also undisputed that the appellant traced their title by way of inheritance on the death of their father, namely Sushil Chandra Saha. The respondent tried to establish that he was inducted by the Sushil Chandra Saha in respect of the suit premises. And since the tenancy is a heritable state, it devolves upon the heirs of the owners and such tenant becomes a tenant under them. It is misnomer that the tenancy would come to an end on the death of the landlord, as the successors who derive title from such decease shall not be bound by the act and the action of the deceased. The law does not recognize such notion nor such principles in relation to such principles. Full stop. The successors, by way of an inheritance, are bound by all act and action of his predecessor, as they derive title through him, and cannot take an independent stand, which either contradict the stand of the predecessor nor evaporates the actions taken by him in a capacity of owner. We do not find that there is any substance in the stand of the counsel for the appellant that the moment the respondent admits the relationship of landlord and tenant between him and the appellant, he is precluded from leading any evidence that his induction was at a relevant point of time when the father of the petitioner appellants was the owner. The moment the respondent admits, আর কি টাইপ হয়ে আসবে আমি এখন অ্যাপ্রিহেন্ড করছি। What would come out after this transcription? I am really apprehensive. What করে দেবো পড়ো? হ্যাঁ ঠিক আছে আমি বুঝে গেছি। There is a fundamental distinction between an admission relating to a relationship of landlord and tenant and the induction as a tenant in respect of a suit premises. The moment even if the admission is made that there exists a relationship of landlord and tenant between the parties to the proceeding, the evidence that how such relationship is established is inbuilt and or inherent into such pleading and cannot be construed as something which is beyond the pleading, and therefore the evidence in this regard is to be discarded. We thus do not find any involvement of the substantial question of law in the instant appeal. The appeal is dismissed, as a consequence whereof the applications filed there herein is also dismissed. এই ফেরত দিয়ে দাও কাগজ। না না, copy of the evidence and all, everything you just এই জাজমেন্টটা রাখো। Yes, call the next matter.
Or I beg to appear on behalf of the shoot for partition.
What is this?
A shoot for partition. I am the plaintiff appellant before your lordship.
Suit for
partition. Dismissed on the ground that I have no share in the property.
You have
no share in the property.
Correct.
Kindly
you are not a co-sharer.
No, not a co-sharer.
Then appellate court
Appellate court affirmed.
affirmed.
I made an application for the appointment of a handwriting expert disputing the two deeds by which the dependent want to demonstrate that the entire property has been sold to somebody else beyond the co-sharers, and those deeds being a 90 years old document, 30 years old document, that cannot be now reopened. But the rebuttable presumption, my lord, under section 4, that has not been considered by the learned first appellate court. My lord, may kindly takes the genealogical routine.
First thing is, did you apply for a handwriting
Yes, I
expert?
applied.
When? In the trial court?
First appellate court.
Why you did not apply in the trial court?
May I just, my lord, to that extent, my lord, I have perhaps no answer to that. But before the first appellate court,
It is by dismissed by virtue of this judgment, or it was dismissed in course of the appeal
no, in course of appeal.
earlier?
No, in this instant appeal.
No.
By the first appellate court.
First appellate court, along with the judgment, dismiss that application, or
Yes. No.
dismissed earlier?
Along with this, along with them.
Along with this.
It is a part of the judgment. My lord, may kindly take the genealogical table once at page 2.
Yes.
My lord, Kanailal Noskar happened to be the original owner. Page 2 of the judgment and degree of the first appellate court.
Yes.
My lord, Kanailal Noskar happened to be the original owner. Kanailal Noskar, my lord, died leaving behind Dhirubala, widow, thereafter Nabukumar Noskar, Bhanumati Koyal, daughter, and Sudhanno Noskar. My total
One son, one daughter, a widow.
Yes.
Then
Total area 8 kathas, out of which Dhirubala, Nabukumar, and Sudhanno, they by a deed sold the property to one Pachu Gopal. Huh? Bechuram Mondol. Bechuram Mondol adduced evidence that
who sold?
Dhirubala,
Yes.
Nabukumar, and Sudhanno. Bhanumati did not say.
Son and the mother
Sold.
They sold their 3/4 share.
3/4 share.
And Bhanumati remained.
Bhanumati remains.
Then
My lord, 2-1 Bechuram.
whatever.
Bechuram in the year 1963.
They sold it to one?
Bechuram.
Bechuram. Then
yes. Nabu Kumar files the WS saying that in the year 1968, Nabu Kumar has purchased the entire property from Bechuram also.
From Bechuram.
From Bechuram. The property which was sold by widow, 2 sons to Bechuram, Nabu Kumar has repurchased it. Repurchased it.
No difficulty.
Bechuram came as a PW2. Bechuram said that neither I have purchased nor I have sold.
But what about the deed?
But so far as the deed is concerned of the 1963, Bechuram's signature is not there. Only the signature of who are selling is there. When Bechuram, may I just
Again, sir, don't
may I just indicate
don't rush. Is a Bengali deed?
Bengali deed. Deed আছে তো? Deedটা বার করো।
This
It's a Bengali deed.
Bengali deed. Does it require a signature of a purchaser in Bengali deed?
It does not require purchaser.
So,
signature of the signature.
It's only an English deed where you both has to sign.
Signature of the seller is required. Purchaser is not required. But in case of in the year 1968, when Nabu Kumar purchased from Bechuram, there also the Bechuram says that I have never sold it because I have never purchased it.
But the deed is a registered one.
Registered one. Both the deeds are registered one.
Then we are saying then he is not a trustworthy witness. Thing is,
but that extent,
please consider
yes,
one
yes,
aspect.
Yes.
A person, if he has a right, he will definitely assert his right and defend his right. A person, when he is aware that I have lost my right, then he can say that neither I had a right nor I have lost a right.
But to that extent, I filed an...
Not losing anything because he knew that I have already executed a registered deed.
I have no liability over the property.
So if there is a registered document, presumption is more in favor of the registered document.
But to that extent, on the basis of the evidence of Bechuram, I took out an application under Section 45 of the Evidence Act for appointment of a handwriting expert.
Correct.
But that application was done.
Did not. Bechuram came in the trial court.
Yes.
So why you did not take out an application for appointment of the handwriting expert?
But to that extent, perhaps I have.
Immediately you could have.
Yes, immediately I could have, but I have taken out application when Bechuram.
Whether Bechuram was confronted with those deeds.
Yes, my lord. Kindly see the evidence.
What is his reaction to that deed?
My lord, kindly see the evidence of Bechuram.
Yes, to us.
এটাই তো এটাই বলি ডিটটা বার করুন দুটো ডিডি বার করুন 68 আর 63 ডিটটা বার করুন কাইন্ডলি সেভেন মানে থার্ড প্যারাগ্রাফ
Just read.
Yes, ma'am. নামগুলো দিয়ে দিন
Where is the affidavit of examination in chief by Bechu?
বেচু ইয়েতে দিন চিফটা বেচু মন্ডলের চিফটা চিফ চিফটা দিন এখানে আছে আমার সাথে এটা এটা এটাই তো চিফটা ইয়েস এক্সিবিট 4 আমাকে কপি দিন
Denying the entry.
এটা তো ক্রসটা চিফে কপি না চিফটা কপি ক্রস তো ক্রস এটা আমাকে আজকে এটা ক্রস এর জন্য অ্যাফিডেভিটটা মাইলটকে দিবেন তো কপি আছে
Big,
মানে in addition to that so far as
yes.
So far as the share of Bhanumati coil is concerned, there is no discussion. And the fact remains that, my lord, I would have taken out an application under order.
Who are you?
I am the son of Sudharno. Sudharno, I am Gautam Nashkar.
Whether Bhanumati,
I have
will
Bhanumati have executed a deed of gift in my favor.
whatever Bhanumati is there, she's claiming, not claiming. It's immaterial here.
No, Bhanumati is a
The first
defendant.
question is that Novokumar has 3/4 share. You, according to him, have only 1/4 share.
But so far as, but I have been non-suited that I have no right, title and interest over the suit property. Because share of Bhanumati,
Because you could not prove the deed of gift by the Bhanumati.
but during the pendency of the appeal, I have purchased.
Sir, have you marked that, produced that particular deed of gift? Was it marked as a?
But I can bring it on order 41 rule 27 before your lordship.
Not know. I do not know. Today, when you are arguing as a counsel for admission, then we'll have to consider what is there. You have not brought that deed.
But even independent of that, my lord, Bhanumati's share has never.
Independent of that, why
separate-
you are bothering? You only thing is you did not have a share. Whether Bhanumati has a share or Bhanumati does not have a share is a different issue. Bhanumati or her heirs will take care of that.
No, I have purchased from Bhanumati has gifted it.
You say apart from that.
Independent of that deed of gift, I am demonstrating that, my lord, on the basis of the evidence of Bechuram, my lord, Bechuram himself has said that.
Is a credible evidence, the witness.
But to that extent, I took out an
He
application.
has said that you have brought him, you wanted him to say this, wanted him to affirm an affidavit. He even does not know what he has written in the exhibit form. He simply identifies his signature.
But he gives the evidence to that extent, and
I do not know that.
For that reason, my lord, application under section 45 was taken out.
Sir, one has to understand. It says, I saw the aforementioned affidavit in the year 2004. Then he says, I cannot say the exact date. Gautam Noskar, you asked me to swear this affidavit. First is the link with you. Is more interested.
He is appearing as a plaintiff witness. I have informed him.
I cannot read the contents of the affidavit just now. I cannot. I can identify my signature as it was written in the big letters.
Signature has been identified. So far as the evidence is concerned, my lord, kindly see the second page. The signature on deed number 80 of 1968 of the sub-registry at Alipur are not mine. So to that extent, my lord, I took out an application under section 45 of the Evidence Act for appointment of a handwriting expert.
Sir, you should have. There is an explanation. When you took out, very innocently, you are arguing. But why you did not take out this application in the trial court? This evidence was produced. The moment you were handed over the copy of this evidence, was it not your duty to immediately take steps for comparison?
But the rejection is on the ground that is a 30 years old.
I am asking you, sir, you are avoiding the leading question. Main question, which troubles you. Why you did not take out an application then and there? I am asking. Why before the first appellant?
But to that extent, my lord, I cannot appraise your lordship what went in the mind of the.
What can be done?
But so far as the rejection part is concerned, my lord, the ground was that it is a 30 years old document. Genuinity, presumption of genuinity is there, but it is a rebuttable presumption.
Onus lies on whom?
Lined up with the plaintiff.
So you.
Yes, the onus lies upon me.
So
I am the carriage of the proceedings.
So.
But so far as that apart, my lord, may kindly consider, my lord, he has denied both the deeds. 1963 deeds, that is 68.
It is more improbable, sir. That is a more improbable. And look at it, nobody can foresee. He is saying something which is absolutely not reasonable, expected. In 1963, there will be a deed of sale by 3 persons. In 1968, the purchaser has sold it and all the deeds are executed and registered. If the document is registered before the public authority, and if it is more than 30 years and comes from a person who is supposed to have the custody, means the proper custody, then the presumption under section 90 of the Evidence Act is that at least the execution is proved, unless you disprove it.
But that is under section 4 of the Evidence Act.
Can it be? I am asking you, what is the language of section 90? Read of the Evidence Act.
presumption as to documents 30 years old.
Yes, I am giving you. What presumption?
Where a document purporting or proved to be 30 years old is produced from any custody which the court in the particular case considers proper, the court may presume that the signature and every other part of such document which purports to be in the handwriting of any particular person is in the person's handwriting, and in the case of a document executed or attested, that is duly executed or and attested by the persons by whom it
What does it mean, sir? That means the presumption as to the genuine signature, the presumption as to its due execution, which is already there. And in order to dispel it, the signature. Now, kindly consider a person who is a PW2. He says that I am 86 years old. And the signature which he appended in 1968 will be the same signature.
Well, so far as the identification of that signature is concerned, my lord, that was produced before him. He said no.
Sorry, he can't. The presumption is against him where mere saying not will not do. Because it's a legal presumption. Unless rebutted by a very strong evidence, that has not been done. Is he still alive? I have a doubts. I have a doubts.
He has expired.
Now, because at the time of evidence he was 86, and that too in 2004.
My lord, so far as the witness is concerned, my lord, I have placed before your lordship.
So,
My lord, so far as Bhanumati.
how you will prove?
My lord.
How you will prove? Tell me.
My lord, the
I can understand.
contemporaneous document
How have you produced a single document of 19?
that I can produce, my lord, by way of order 41 to 27.
I do not know 1968 document.
My lord, contemporaneous document, my lord, as I have been told, my lord, of because the son has identified the acted as an identifier to the signature in the affidavit of the Bechuram. Son possesses contemporary document of the father, which can be produced in order 41 rule 27 as an additional evidence in the event, because the first appellate court has.
You could not produce a single document.
But the rejection was before the first appellate court, and this is my next forum, and I can produce under order 41 rule 27 before your lordship.
then you'll have to show that what constrained you not to produce that document before the first appellate.
But that
Simple saying will not do. There are grounds which are enumerated under Order 41, Rule 27.
But that I will try to convince your lordship.
This is what nothing. It is not there. Nothing.
That I will try to convince.
Unnecessarily, we have given you enough latitude and an opportunity. I think it's
But
high time one should.
I am before the highest court of the state. That much liberty I should be given, which your lordship has granted to me.
I have given.
But so far as the Bhanumati's share is concerned, my lord.
How you are concerned?
I have.
You could not produce before the trial court, before the appellate court. You can't argue. Have you not seen the earlier counsel has cited a judgment before us? Something which is not there on the record at the bar, you can't make out a case.
But that document I can produce before lordship because.
Why I will.
But for that reason, the provision of order
27
is there.
Sir, when you drafted the memorandum, you know everything. You could not take any steps. What is the role of the advocate when he represents?
I have not drafted it. I take the responsibility, but it has been.
Sorry, when you were consulted, you should know before it is listed as Order 41, Rule 11. You know everything, but you still.
But so far as the document I can produce before lordship, I have been not suited. I have a share. It has been gifted by Bhanumati in my favor. That I can produce if your lordship grants me 1 day time.
Nothing.
But 1 day time, I can produce it. But my share is there. 2 quarters I have got it by way of gift.
Now you argue, and I will not say any words. You argue in your own way, and then give us a time to dictate the thing. If you do not realize what is passing through the mind of a judge, I am really at loss.
That document was not been produced before the learned trial court or for the first appellate court. I had the opportunity to place. I will file an application under 4127. Kindly grant me a week's time. By way of 4127, I will bring that deed before your lordship. Because the first appellate court has made a finding that I have no share in the property. This much I can submit to your lordship. Instructions. Instructions.
It's a big difference.
Suit is pending for the appeal position. Again. Into the part. He claims
Where is the evidence of the DW1?
DW1 evidence work. DW1 ডিফেন্স উইটনেস নবকুমারের ছেলেরা DW1 চিফটা পেজ Yes, my lord. Chief and cross. I've marked it, my lord. I folded it.
Out of Untrustworthy. Yes, thank you. For orders to put without conflict. For orders tomorrow?
My lord, it would be much obliged.
The defendant is the appellant before my lord for a suit for eviction under 106 of the Transfer of Property Act.
What?
106 manner of the transfer.
What?
Judgment of affirmance manner I have done.
Obviously.
Say, my lord. It is up to your lordship.
106, notice is proved, that's all.
Yes, yes, yes.
That's all. No
No.
ground is required, nothing is
Nothing.
required.
Only one thing, my lord, our defense is that it is lease is for manufacturing purposes. There was notice.
It was filed after the entire period.
No.
So even if there is a shorter period given in the notice,
Yes,
but if the suit is filed after that, then what remains?
nothing to say.
So yeah, actually different period of
नाम
six.
नाम
Notices have been proved.
Six months. 6 months. Arrangements of 167.50 rupees 167.50.
Stamp the deficit court fee.
ওটা তো মানে এমনি জাজমেন্টের ডিগ্রিতে ডিফেক্ট ছিল, সুদ ভ্যালুতে দিয়েছে।
What?
No, properly court fee has not been.
20 rupees you have paid for preferring an appeal. What are you doing?
From the decree of the appellate court, managerial officer. 212 and
10 rupees. Stamp on power 20 rupees. What is this? Talks about the stamp. What about the court fee?
Because
stamp for memorandum of appeal.
That is wrong. Stamp is different. Court fee, trial court.
Trial court. 597.
No,
cost of
189.50.
189.
So, trial court is perfect. 167. Go, file it.
এখন কি করে দিব?
Go, deposit.
Tomorrow he will
go and deposit.
Tomorrow he will deposit and you know she will pass the order.
Tomorrow.
কত টাকা বললো?
167.
167.50.
Just wait. Okay.
Yes. Eviction category. Score. Suffered. Dismiss.
I could not file the learned trial court judgment at the time of filing. I may file it within this week, my lord. My client could not.
What is the suit for?
Suit for declaration of easementary right and injunction. Judgment of affirmance dismissed by Procedural.
Both the courts below. What is the easementary right? Easement of necessity or prescription?
Prescription necessity. It is a common passage lying in just beside my house. Two of my adjoining owners of the adjoining passage, they were obstructing. And I filed.
Show us. Where is have you filed the judgment of the trial court also? Photocopy?
Photocopy.
Yes, it is here.
Photocopy.
Show us what is the wrong.
Not Lane trial court, both the court below dismissed it on the ground that food property is not sufficiently described. This is the one of the grounds.
Yes.
And another ground, misgender party, non-gender of necessity party, because all the owners adjoining the passage, they are not been made party. I have made party only 2 of them who are making the obstruction.
No, but once you sought for a declaration, then that it is a common passage, then others have to be made a party.
But all of them are not making this obstruction.
No. Had it been a suit for permanent injunction only, I can understand that the persons who are obstructing you are making them a party. But it is not a simpliciter suit for permanent injunction. You have sought for declaration also that it is a common passage. Then whoever is enjoying that passage, will you not make them a party? They may assert that it is not. Maybe a private passage.
Only against cause of action arises only against those 2 persons.
Are you not realizing what we are saying? If that being done, no difficulty. Then argue. Give me the law point.
Kindly make it day after tomorrow. Blood I shall.
That this matter is pending for a pretty long time.
I am not taking much time.
No, you are taking time. Whenever it is
Tomorrow.
whenever it is called, you are taking time.
No, Milord, first time.
First time it is matter is listed. No.
No, first time. Matter was listed. LRC was not sitting.
Not this week.
Tomorrow.
Tomorrow?
Wait, tomorrow, day after tomorrow, any day as LRC. Any day as LRC will take.
Today is a good day.
No, today will not have. I will not
Not today.
Question, not I am only.
Expressed expert. No, dismiss. आपके क्या इस 2 को ये चेक किया था आपके सामने आपको अभी आ रहा है तो
Recovery of consideration. Further licensing. The deed is dismissed. Dismissed. Dismiss. Yeah. No, I am for the appellant. There is a section 5, 42 days delay.
Service. Service 3 weeks else.
সার্ভিস কি করেছিল কে কেউ আসবে কি বল দুনিয়াতে একটু দেখেছি
My lord, I am for the appellant petitioner. Pursuant to my lord's direction, I sent the copy by speed post. It was sent, my lord, on 3rd of February 2024, but the track report is not complete. It was sent, my lord, 31st of January 2024. The track report says, my lord, it is bagged. No report has come. And report is still 3rd of February. After that, there is no report.
Not this week. Not this week. Collect it.
In previous matter, I said, there was no service, we served. I have the affidavit of service as well.
Was there any direction for service?
No, no.
Sir. Yes.
Affidavit of service আছে তো আগে কোনো ডাইরেকশন ছিল না তো তারপরেও সার্ভিস করেছে এটা সার্ভিস ঠিক আছে তবু হ্যাঁ তবু সার্ভিস
25, this is my appeal. My learned junior was arguing, kindly permit him to argue. This is maiden matter. I told him you should. For still officially.
Lordship,
suit for damages. It's really yes, it's like that. And instead of making it definition of the property that they have to top.
Yes.
Lordship, the appellant number 2, that is the CEO of the company, on 4th of August 2023, Lordship, the defendant number 1, there was a international flight that was cancelled by the and after that the defendant 1 could not provide simple PNR. What was he was she could not fulfill her obligation, which was incumbent on her lordship. Thereafter, lordship, on 7th of August 2023, without informing the CEO and HR of the company, she left the laptop and all, and she left the company. Then she apologized for that in WhatsApp messages, and what she sent in the WhatsApp messages, lordship, she categorically deleted those messages. That is in page 66, lordship. I can kindly come to the page 66, lordship. So she categorically deleted those messages where she has apologized for her conduct, lordship. So later on, lordship, on 8 August 2023, she apologized, without intimating the company, she left. Then on 24th of August, lordship, company sent her a mail for termination of her service, as she could not inform the company that she will join back. One thing, lordship, may I just indicate one point, lordship? On immediate 1 year before, 2022, 8th of August, she herself requested the CEO of the company to join her daughter in the company as an intern. So it is apparent from her WhatsApp notes that she herself agreed that company is a well-reputed company. And when she was terminated on 25th of August 2023, at this juncture, lordship, she complained against the company in the FB, in her FB pages on a live video, Facebook. She uses defamatory language as a company where there is a ex-associates, pageant employees, ex-employees of the company. So that harm the reputation of the company in the eyes of the other people in the lordship. I'm led by senior.
He is a bit nervous. He knows the facts better than this. Well, I filed this employee. Once she was removed from services, there are live videos that can be posted on the web page of Facebook. She posted a live video where she made certain defamatory comments against the company and the persons in charge of the company. She was put on notice. She was called to take down this video. It was not complied with. We filed the suit, praying for an interim mandatory injunction, though the injunction, I'll be candid, he has indicated it's very wrongly drafted, the petition. It's a copy-paste error. I know my lord deprecates such practice. But to be fair, he has not drafted it. My lord, someone else had drafted and moved the petition in the court below. My lord, we prayed for an interim mandatory injunction upon the defendant number 2, which is Facebook, and on the defendant number 1, who has published the post, to remove that post. These are the common parlance, and a lot of judgments passed by the Delhi High Court on such counts. These are called takedown orders. We prayed for that interim order before the court below, because as long as the video will be available on Facebook, my loss would be continuous. And in such circumstances, perhaps I was entitled to an order of interim mandatory injunction.
What is that would tarnish your reputation? Till date, it has not been said. Many things is said. He said that.
But Marad, that video is persisting online. This is not something that this is for the world to see.
If the video may praise your
No, it does not praise me at all. Does not praise
that is
me.
why what it says, how, to what amount it would really affect your
Well, that is
image.
all mentioned in my plaint. But kindly sees the.
I have not been able to
I will
as
show
of
it to you.
now that what is that.
Plaint.
What according to you make
Kindly comes to
belittling your
kindly
company?
comes to the plaint, which is at page 107 of Marad's
Yes.
brief. There, I will just prayer number.
Yes.
I will just indicate Marad. But kindly comes to paragraph 22 of the plaint, which is at page 115.
Yes.
If may I read it out for lordship's convenience? It is humbly submitted that the defendant is making false allegations of POSH. This is the Prevention of Sexual Harassment Act.
At the
On a live video made and published by the defendant number 2, by the defendant on 2nd September 2023 on her Facebook page as a vindictive step to cause harm to the repute and goodwill of the company, its ecosystem, and management of the company as an afterthought and excuse to not to repay the dues in company when it should, again, it should be she was asked to repay, when you were asked to repay, linked to such defamatory content is such and such, whereas it will be evident from the records and communications made between the parties till 13th August 2023 that the defendant had been pursuing the HR manager to retain her position as the personal assistant to the CEO. In fact, one of the main reasons for the defendant to back out from rejoining her offices is that she feared that she is being replaced as the HR manager is already looking for a personal assistant to the CEO. Particulars ছিল ওগুলো কোথায়?
That is what we wanted. That what? What are the particulars?
I will just indicate it to your lordship.
Very vague. Last time also we said there is a very vague one.
Kindly comes to paragraph 41 onwards. The particulars should have been there. I will be has to be. The imputations have to be set aside. But maybe not in particulars, but in pleadings, they are set out.
No, sir.
Kindly seize,
No, sir. You'll have to.
But it is not particulars of fraud, will kindly.
It's not a fraud. It's not a case of a fraud. It's a case of I would say the damages.
Not imputation, but I need to set out
it's a case
imputations
of
against
defamation.
me.
Please, you'll have to spell that what is the defamation.
Kindly comes to, for my lord's convenience and satisfaction, kindly comes to paragraph 41 of the plaint.
Yes, we are.
Which are page 122. It is humbly submitted
only
that
to repay. Then she published in a Facebook.
42 lordships kindly sees.
What is that?
No, there is allegations of the defendant defaming the company.
Lowered the dignity. How?
For that one, the video has to be placed before
There must be the transcription has to be done.
Then may I come back to the transcription? Then I am not
You do it. How can there are many things.
If your lordship
Everything
permit
does
me, I
not
can
mean
come back with another device and I can show the video to your lordship.
No, not video. We wanted to
transcribe the transcription of the
transcription has to be done.
Kindly record the order to that effect. I shall come back in a week's time with this.
What is the valuation?
7.5 lakhs.
7.50.
50 lakhs. It will appear at page 108.
What a valuation statement also there is a leave is granted to the advocate and record of the appellant to put in the valuation statement in the memorandum of appeal here and now. Who is the advocate and record? So he'll have to put. The appellant is directed to produce the transcription of the video allegedly uploaded in the Facebook account
of the defendant number
of the defendant number one on the next date. Let this matter be listed on next week.
I'm grateful. I
Every
understand.
word spoken does not mean that.
I know. The imputations had to be there. And I will not apologize for the prayers in the injunction application. I had told him that this will be a serious problem before my lord.
All the next.
Yeah, I'm grateful, my lords.
Transfer. In this case, the definition. सब तो don't, what to read? For hearing tone. The case of a gift. So long. Share. This idea. It's not difficult. Right. There is a different word. Dismiss.
But I'm for the appellant. The Lordship has been pleased to hear this matter extensively, and the matter was made CAV after hearing the parties.
Which one?
The because it arises out of a order passed by the learned court below, by which an application under Order 711 was partly allowed, and plaint was returned to be filed before the learned NCLT. Lordship has held that in the admission, when the appeal was admitted, Lordship had held that it should not be a F80, it should be an FMAT, because although the order records was passed under Order 7 Rule 11, but actually in effect, Order 7 Rule 10 application was allowed. Application of Order 7 Rule 10 was done. So it was renumbered as FMAT, and thereafter it was hard. Mr. Ghosh was leading me, and on that side, Mr. Siddhartha Banerjee was appearing and argued. Both of them argued extensively, and Lordship has been thereafter it was made CAV after hearing the parties. But
There is no order of CAV. That is what I am asking.
18 December 2023.
18 December it was last heard.
It was
18
ordered.
December says list the matter 1 week after the Christmas vacation under the heading for orders.
For orders.
So it is not a CAV in that sense.
Only one indulgence may I seek, Miller.
Sorry, we can't, and we don't know what is there.
We have to argue, re-argue again.
No, you argue it on Monday. We are fixing it.
Milord, the advocate record appearing in this matter, Milord, has been hospitalized due to medical emergency. Milord, the operation is going to be held tomorrow, Milord. Milord, I am praying for.
Who is the advocate on record?
Mr. Jyoti Raut.
Who?
Miss Jyoti Raut. For respondent number 25. I am being told to appear today, Milord.
No, you were represented by Mr. Siddhartha Banerjee.
Yes, Milord.
So he will take care of that.
Assisting him.
No, he will take care of that next Monday.
Next Monday.
But kindly at least 1 week, if my lord kindly.
Monday, next Monday.
Next Monday is a monthly day, 4th March. We're on that day.
Will be there on Monday. একটা এই ফাইলটা নিয়ে যে আগের ম্যাটারে একবার কালকে আমাকে দেখাবে যে আগেরটা এটা সোমবারে রেখেছি Just let me know. Such a long time has elapsed. The sale of the property has been done. It has been done in 2005. Now in 2011.
My lord, I am for the appellant.
Yes.
My senior is ill due to I not to take place.
You are not, sir. You are more competent. Do it.
Yes, sure.
Sir. Please do it.
Actually, this is a standing instruction from my senior. He's due to ill.
You are the advocate in record. You will give an instruction or the senior will give an instruction. You will
I am
give
not
an
in
instruction
advocate.
to him. Do it,
Please,
do it, do
please,
it.
please,
You
please.
are more competent. Do it.
My lord, I am not thorough along with the
You
petition.
have drafted the petition, signed the wakalatnama. You know everything, sir.
My lord, please.
You can place the fact. What is that?
I am not
Please do
thorough,
it.
please, my lord.
Please do that, sir.
Please, please, my lord, sir. I am not thorough.
What? You are a very thorough person. Don't worry.
I am not thorough.
No, I have a full confidence in you. You do it, please.
I don't have any knowledge regarding that.
And you are an advocate in record. You do not have a knowledge of the matter. What are you so talking about?
Please,
Sir,
please.
what are you saying, sir? I think you are pretending that you do not know. That's a modesty. I appreciate it, but do it, do it.
Please, please,
Do it,
please.
sir.
My lord, please.
Do it. You know everything.
This is my beyond knowledge. Please.
What beyond knowledge? His matter is filed way back in July.
Right.
Now we are in the fag end of February.
Right.
So 7 months has elapsed, sir. Do it.
Please, my lord.
What?
Not today, please. Not today, please, my lord.
Tomorrow you assure that you will do matter.
I will try.
Give an undertaking that you will you will do the
My senior will be here. My senior will
No,
be
no,
here.
you have to do it. We will grant adjournment. You said you are not thorough. Be thorough today evening. Come and do the matter tomorrow. Give an undertaking that you will do it. We are adjourning it.
I have to take the instruction, my lord.
What instruction? You do it. You are the advocate in record, sir. You have signed the Vakalatama in this case. What is your good name?
Oh. I'm not in advocate record, please.
So who is the advocate? Mr. Anit Kumar Roket.
Yes.
He still signs Vakalatama. Yes?
Yes, yes. Yes.
Will you ensure his presence tomorrow?
Yes.
Giving an undertaking that you will bring him tomorrow?
Undertaking my notes. My senior will be here tomorrow itself.
Undertaking?
At least, please, this is my submission.
Not today.
Oblige me, sir.
'29, I am paying for the time tomorrow. I have engaged leader in this matter. Saying not today.
Why, sir?
I have engaged leader in this matter. There is concurrent
Why leader?
concurrent finding of the both.
Sir, you are competent, sir. Why? You are the advocate in record. Who is the advocate in record? What's your good name? Yes? Subroto? You are the advocate in record, sir.
Both we are.
So do it. Do it, sir.
Kindly, my lord, and not today, my lord, because I have engaged leader as per instruction of my client.
What instruction?
Leadership we have forget that. Concurrent findings, my lord, both courts. This is my residential property. Only dwelling house, my. So kindly not. Just here. It is the first time which that I must.
Sir, on 7th, you mentioned by Mr. Hirakumar Basu. You wanted this matter to be listed. Don't you know at that time that you have to engage a senior? Why you mentioned the matter?
Instruction was senior.
Sir, then why you mentioned the matter, sir?
That
Why?
is true, my lord. As per instruction.
Sorry, I do not know. You'll have to argue. Tomorrow, only thing is, you have to argue.
My lord.
Senior or no senior?
My lord, item number 30, I appear for the appellant. My lord, Mr. Siddhartha Banerjee is due to fever, could not come to court. I'm praying for not this week.
I'm being led in the matter for the.
Lord, I have a preliminary objection that the appeal has become infructuous.
He is ill, suffering from fever. You have a preliminary objection.
It's end of the day. I have a preliminary objection, my lord, with respect to the matter. But since Mr. Banerjee, my lord, is ill, my lord, there's nothing I can do.
Not today.
Not this week, my lord.
Yes.
Affidavit of service.
Then argue the matter.
Deeply acknowledged.
Grateful to Lachun.
31 also I beg to appear on behalf of the appellant.
তো মোটা একটা ব্রিফ নিয়ে
My lord, this is a case of, my lord, the trial court and appeal court, the concurring finding, the dismissal of the suit.
You are a plaintiff defendant.
I am the, my lord, the defendant in the suit.
Dismissal of the suit.
My lord, dismissal
Concurrent-
of, no, dismissal of the my trial court, my lord, decreed the favor of the, my lord, the plaintiff. Thereafter, I challenge before the, my lord, the appeal court.
For
Suit for my declaration of the wife. There's a dispute between the two wives.
action of the wife.
Declaration of the wife, two wife, my lord, the regarding, my lord, dispute the regarding pension and other determined benefit. My client has, my Nimai Chandra, that's very deceased, my lord, he has, my lord, the twice, married twice. My lord, first wife, my lord, there is a dispute between the matrimonial dispute 498 proceeding, they have been left from that matrimonial house. Then they are having another 4 children. And my second wife, my lord, second time, then Nimai Chandra was married. And that marriage has not been recorded.
It is relating to woman.
My lord, the second, my lord, the wife, my lord,
Even after sensing